All right. And Ms. Fuller, do we have you back? Are you frozen? No. I think Ms. Fuller's rejoining us.
Yes, Your Honor. Can you hear me?
I can now. Great. All right. So we have started the live streaming. We've had the entries that have happened at this point. So that way the scoring jurors and myself know exactly who the teams are, who represent the plaintiff and who represent the defendant. You also have that in your name signatures via Zoom, which is great as well. Hang on one second. Let me just double check. All right, that's an issue that's going to another thing. Sorry about that. Okay, so we have this. If I may, I would like to just make sure that we go ahead and go with the swearing in. So if I could just have everyone please raise your right hand. Do I have Ms. Fuller as well?
Your Honor, we're still working on these technical difficulties. I apologize. We're trying to get this resolved as soon as possible.
You know what? That's okay. No worries. No worries. We won't hold it against you. It's totally fine. Everybody just relax for a moment and we'll get going. Okay? One little thing for housekeeping as well. Well, I probably should wait till Ms. Fuller is in before I go forward with that.
I think we've made some changes, Your Honor, and I'm hoping that those changes will be sufficient. I apologize for the delay.
No, it's fine. We'll get going. That's fine. It's just a couple of minutes. It's not a big deal. So if for whatever reason there's, break in case of glass, I believe that there's the phone number that you could call in. And if we had to do it by audio, we would do it that way. But we'll just continue to try to make it work. This is one of the realities of the time we're in right now. And everybody just relax and we'll be just fine. I'll do the swearing in. One little housekeeping matter from the court is that I would like to have your cameras off for the opening statement. And opening and closing statements. So opposing counsel, if you can turn off your camera and then we'll just give the full screen to whoever is opening or closing. The rest of the time, the opposing counsel may have their camera on, but I would prefer that the other people then have their cameras off. Okay, so it'll be just like the two participants. And I may try to have my camera on just so that it's easier to make rulings and the rest of it from that point. But we'll try to give you the full stage for the opening and closing. Okay? All right. Ms. Fuller, are you still able to hear us? Everything okay so far?
Yes, Your Honor. So far.
All right. Well, then let's try this again. Let's do the swearing in. Please raise your right hand. Please indicate by saying, I do, if you swear to abide by the rule of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do.
Now calling case number 082263, Cam Donaldson versus Karen Basha. All right, I found out earlier that there were housekeeping matters, okay? So we'll start with the plaintiff. Plaintiff, if you'd like to go ahead and address the housekeeping matters.
Yes, Your Honor. During the course of this trial, counsel may ask you to approach for a sidebar. We ask that this be done constructively and we be allowed to remain on the video conference so that all evaluators will be able to hear our arguments.
Of course, that'll apply for both sides.
Your Honor, may we be permitted to stand during opening statements and closing arguments while remaining seated for our directs and cross-examinations?
Sure, that's fine. For both sides, it's totally fine if you would like to stand or sit or move about your space. Just try to stay on camera.
Would Your Honor prefer us to stand for objections and remain or remain seated and closer to the video conferencing camera?
Yeah, it's whatever you'd like to do. Standing works well. We're trying to get a feel for this as well. So whatever you feel comfortable with, whatever you're prepared.
And lastly, would Your Honor prefer that we formally tender the expert witnesses in this case?
Yes, please. We'll go through the foundation of that.
We also have met and conferred with opposing counsel, and we stipulated to the use of an exhibit in opening statement.
Okay, for a housekeeping matter, that's fine. And the other side, you're fine with this for defense?
Yes, Your Honor.
Okay, great. Any other housekeeping matters?
That is all our housekeeping matters, Your Honor.
All right, then from the defense.
Yes, Your Honor. First, just like to verify that today's proceedings were using the Federal Rules of Evidence and the Federal Rules of Civil Procedure.
All right.
Pursuant to Local Rule 44, I just want to inform the court that my co-counsel and I will be utilizing the Google Hangouts iPad app to communicate with each other during today's trial. No other participants will be on that chat, just my co-counsel and I.
Okay, that's fine. I know that I'm familiar with the rules.
I'd just like to verify, Your Honor, that for publishing exhibits, we are permitted to use the share screen function.
Yes, and so just as a clarification, I'm sure you're aware of this, but the way that it works is every witness already has the case packet in front of them, all right? So if you're going to lay a foundation for an exhibit, you will not show that exhibit until that exhibit has been entered. And once it's been entered, you may certainly use the share screen.
Yes, Your Honor. Because of the rules of this jurisdiction and our own space constraints, we have our advocate in one room, we have a technology advocate in another, and then a witness in a third. Because we only have the 3 rooms to work with, my co-counsel and I will be using this room you see me in now when we're presenting or when we're addressing the court, and we will just change the name accordingly. Just so you're aware what's happening there.
Okay.
And then just to introduce the technology advocate I mentioned, his name is Eddie Villarreal. I think that you noticed him on the call earlier. And so if we need like something done on the screen, we will be addressing him during the trial.
All right, that's fine.
Just to verify, Your Honor, that the witnesses for the timeline in today's case are constructively sworn in.
Yes.
Thank you, Your Honor. And finally, may we assume that the jury instruction has been read prior to closing arguments?
Yes, it will be.
Thank you, Your Honor. And we just have the 2 motions in limine that.
All right. We will address those in turn. So we'll go plaintiff and defense. Okay, great. Timekeepers, if you can keep track of this, you may proceed, plaintiff, with your motions in limine.
Yes, Your Honor. We are here today because the defendant, Karen Beja, killed her husband, forged his will, and stole all of his assets. Now, Your Honor, our first and only motion today is to exclude 2 photos that were produced in discovery, which appear to be debris floating in water. No one will take the stand today who has any personal knowledge as to what these photos are, where they were taken, or who took them, and therefore we wish to exclude them as they are lacking in foundation and unduly prejudicial under the Federal Rules of Evidence. Your Honor, reference to these can be found on page 9 and 10 of the exhibit packet. If you have the PDF open, it would be page 61 and 62. However, if it would be easier for the court, my co-counsel could share the screen with you if Your Honor would prefer, and you could see those exhibits.
I'm familiar with the exhibits. No need to share them and take the time. Response?
Yes, Your Honor. The defense has no intention of using these photos in our case today, so we have no objection to them being excluded.
All right, that makes that one easy. Any of those quote unquote debris photos will be excluded. Next motion.
Thank you, Your Honor. No further motions.
All right. Now let's turn to the defense.
Yes, Your Honor. Our first motion limine, for a brief factual background, there was a Lou Donaldson filed for a temporary restraining order against his wife, Karen Beja, who's the defendant in this case. That temporary restraining order was denied, and we would move to exclude any mention of this temporary restraining order denial. This is an exhibit. It is marked for identification with Bates 0016. We moved to exclude this exhibit because it is more prejudicial than probative under Rule 403. As I stated, this temporary restraining order was denied by a court of competent jurisdiction. Any delving into this would be more prejudicial than probative under Rule 403.
All right, and a response from the plaintiff.
Yes, Your Honor. The probative value of this request for a restraining order substantially outweighs any prejudicial effect. Specifically, this document was signed by Lou Donaldson, who is the victim in this case. He signed this document 2 days before he allegedly signed a will, which we have a good faith belief the defense will present today as Lou Donaldson's last will and testament. The statements made on this restraining order go to his state of mind at the time when right before he disappeared.
And do you intend to try to enter that particular exhibit, or are you going to be referencing it?
Yes, Your Honor, as well as our expert relied on this exhibit in their investigation, the signature specifically, in comparing it to the will in question in this case.
Your Honor, if I may.
I'm sorry, counsel, that got cut off. And so if you don't mind just finishing your thought, Ms. John, I'm sorry, I missed that.
Oh, no worries. I was just also going to clarify that these documents were signed 2 months prior to Lou Donaldson's disappearance, but 2 days between the alleged will in question and this restraining order request.
All right, and if I may, I'd like to ask, is this propensity evidence in any way?
No, Your Honor, this is not going to the character or propensity of any of the witness. It's being used to assess not only the credibility of the experts in this case, but also to describe the state of mind of Lou Donaldson at that time.
Response.
Yes, Your Honor. Opposing counsel mentioned that they especially need this exhibit for the signature contained within it, and the defense would have no objection to their redacting the remainder of the exhibit and only using the signature for their expert witnesses comparison. However, the remainder of the exhibit is more prejudicial than probative under Rule 403.
I am fine with using the signature in and of itself. So we can establish that at this point in time, that there could be a comparison to this court document that was also signed by Lou Donaldson and the authenticity of it. I'm leery without necessarily having the foundation for this temporary restraining order or any information about the will or the rest of it. I feel for this to basically just say, that's fine, it can come in. It feels very much like propensity to me. It feels that there is the danger of 403, but I'm not going to shut it down at this point. It depends on what comes out at trial. So I'm going to reserve ruling, and we'll kind of see how this plays out, and we'll have an opportunity to see where things stand. But I would appreciate contemporaneous objections whenever this starts to come in, and we may be doing some redacting if that's the case, and we can do that either on the fly or we can do it constructively and we can address it later. All right, but those are my thoughts at this time. Signature can come in, and the mention of the signature on a court document. However, the temporary restraining order without foundation at this point is not going to come in. We'll see how things play out. That's my ruling. I'm reserving ruling, so there is still that opportunity. Okay?
Yes, Your Honor.
Additional motions.
Yes, Your Honor. Our second motion limine is in regards to a video and the transcript that goes along with that video in the case record. So this video is of a man who makes an incriminating statement about the defendant, Ms. Beja. First of all, the entirety of the video is inadmissible as hearsay. And additionally, it would also be more prejudicial than probative under Rule 403. The man makes many derogatory comments about Ms. Beja, which make its prejudicial effect outweigh its probative value.
Response.
Yes, Your Honor. This video is admissible hearsay pursuant to a stipulation which both parties have already agreed on, that Exotic Bob, and specifically this video, is a testimony from an unavailable witness today. And in
Go ahead.
If I
Were you
may,
going to finish your thought, Ms. John? I'm sorry.
Yes, Your Honor. Also, in response to, I believe, a 403 claim that opposing counsel was making, the statements in that Exotic Bob makes throughout the video go to show not only that the defendant has made similar threats, which we have a good faith belief will come out later in the trial that she made to other witnesses in this case, as well as it's a confession from the defendant as to that her husband was put in a meat killer or in a meat machine.
Response, counsel from the defense.
yes, Your Honor. As opposing counsel mentioned, this witness is an unavailable witness under Rule 804A. However, under Rule 804, the statement also has to meet one of the elements under Rule 804B. So it isn't enough for the witness to merely be unavailable. The witness also has to meet one of the requirements under 804B before the statement can be admitted. Additionally, as for the 403 argument, the video even includes a song, and it's just I can't see any probative value in especially the song portion of the video, Your Honor.
Counsel, your response to the song portion of the video.
Yes, Your Honor. The song is just the format in which Exotic Bob chose to testify throughout his video or convey information. However, the words he is actually saying are foundational in explaining who he is, as well as his relation to the defendant and how he knows her.
I am familiar with the song. The performer is quite a character, but I believe that I'm going to allow it in, and to address defense counsel for the counsel, if you can just answer this question for me. The statements you're worried about, one of the statements is supposedly from your client, the defendant. Is that correct?
Yes.
Admission of a party opponent?
It,
all right. Go ahead.
Sorry, it would be not that level of hearsay. I understand the party opponent exception, but the level of hearsay of Exotic Bob himself speaking on the video.
All right. And I'm also familiar with that. Would there also be the possibility of him making some sort of statement against his own interest or something like that?
Yes, Your Honor. Those statements are covered under 804B3 specifically.
All right. And from Ms. Fuller?
Yes, Your Honor. In the statement against interest, the problem is we have no facts here showing that this statement is in fact against Exotic Bob's interest. As you can see in the video, he is in prison. We do not know what he's in prison for. For all we know, he's already been convicted of this crime. Therefore, we have no way of knowing if he has any interest against making these statements. On top of that, I mean, he could be informing. We have no facts to prove what is required under the statement against interest exception under 804B.
Ms. Fuller, Ms. John, this is well argued, and I do appreciate the argument. However, based on the stipulation, based on some of the other aspects, I may be appealed later, but we're going to go ahead and allow that. So the statements for Exotic Bob can just come in either to play or to use it as a transcript. And that'll be my ruling. Any other motions?
No more motions, Your Honor, but I just would like to ask, because you have reserved ruling on the temporary restraining order in its entirety, we would just ask that opposing counsel not use it in their opening statements.
That is, that's fair. Is that going to cause any issue?
No, Your Honor. With that, plaintiffs are ready for trial.
All right, and defense?
We stand ready to open, Your Honor.
Great, then let's proceed to openings. And as I had stated previously, I'm going to darken my camera for opening statement and closing, and opposing counsel should do the same. That way the stage is completely, the well is available to the advocate. All right.
Your Honor, may I proceed?
You may.
20 years ago, Lou Donaldson met a woman that would steal his heart, steal his life, and steal his company. That woman is the defendant in this case, Karen Beja. Now, this lawsuit that brings us all together today was filed by Cam Donaldson, Lou Donaldson's daughter, on behalf of her late father. In the summer of 2012, Cam Donaldson's world came crashing down. In the span of a few days, her father went missing without a trace. Her stepmother, the defendant, steals Mr. Donaldson's will and presents a forgery, and then proceeds to take over the Donaldson family business, the Wild Wildlife Emporium, and firing Cam Donaldson in the process. The defendant took Cam Donaldson's father, took her job, and took her inheritance. But what she can never take is Cam Donaldson's right to seek justice. Good evening, members of the jury. My name is Morgan Mays, and here with my co-counsel, Rebecca John, we are proud to represent Cam Donaldson. And before we go any further, I'd like to introduce you to her. Cam, will you please come join us? This is Cam Donaldson. Her and her father have had a close relationship from the start. This is Lou and a young Cam Donaldson. The two worked side by side for 20 years, working to save and preserve big cats. She had the opportunity to spend quality time with her father almost every day of the week, and her life has been completely changed by her father being taken away from her. Thank you, Cam. Now, members of the jury, the issue for you to decide today is whether the defendant will be held responsible for the killing of Lou Donaldson and determine what is the value of a relationship between a father and a daughter. As the party bringing this lawsuit, we have the burden of proving by the greater weight of the evidence that it was the defendant's actions that caused Lou Donaldson's death. Now, this is a burden we gladly accept because the evidence will prove this by showing two things. First, Lou Donaldson provided the defendant with a better life. And second, she killed him to keep it. So let's talk about the first thing the evidence will show. Lou Donaldson provided the defendant with a better life. To truly understand this case, we have to go back about 20 years ago when Lou Donaldson first met Karen Beja. At that time, Lou was a successful businessman, married, with a child. The defendant was single and broke. You'll even hear from the defendant today, and she'll tell you that she came from a poor upbringing and describes meeting Lou Donaldson as being rescued by her Prince Charming. The two eventually married, but fast forward 11 years, their marriage was on the rocks. Lou Donaldson wanted a divorce. You'll learn today that the writing was on the wall for their relationship, and a divorce would have changed everything for Karen Beja. A divorce would mean she'd lose her cats, lose her man, and lose her money. And you'll learn that she made her choice. Get rid of the man and keep the cats and the money. So that takes us to the second thing the evidence will show. The defendant killed Lou Donaldson to keep a life that she thought she deserved. So with Lou Donaldson disappeared, she took over his life's work at the Wild Wildlife Emporium and secured two big pots of money. First, Lou Donaldson's life insurance policy, and second, his estate. So you'll learn today that Lou Donaldson was last seen on a Friday. And less than 48 hours later, the defendant breaks into the offices at the Wild Wildlife in the early morning hours and sets off the alarm. Cam Donaldson rushes down to the scene to check on the location, and what does she see when she gets down there? But the defendant walking out of the offices that had just been broken into, holding a lockbox that was kept in Cam Donaldson's desk next to a man holding lock cutters. Now you'll learn today that in that lockbox was Lou Donaldson's true last will and testament. And the evidence will show that this document the defendant is alleging as Lou Donaldson's will is not the same document that was in that lockbox. She broke in on a Sunday, took over the business on a Monday, and fired Cam Donaldson soon after. The cats were now hers, and she got rid of everybody that could stand in her way. Now you'll learn today about this alleged will that the defendant is presenting that was never before seen by Cam Donaldson or her family. You'll also hear from Taylor Pride, who is a forensic investigator and handwriting specialist, who conducted an investigation and determined that this will was a fraud, and Mr. Donaldson's signature on that will was forged. With Lou Donaldson gone and the wild wildlife in her hands, the last step was to get the money. And you'll learn today that she had Lou Donaldson declared dead and then immediately collected on his $5 million life insurance policy and then officially inherited his $5 million estate. Now, members of the jury, at the end of this trial, my co-counsel will stand before you and ask you to place a value on the relationship between a father and a daughter. Where it might seem truly impossible to compensate a daughter for the premature loss of her father, I ask you, listen to the closeness of their relationship. Listen to the dinners Cam will not be able to have with her father, the job she lost, and the family business that was taken away from her. The evidence will show the defendant stole Lou Donaldson's heart, stole his life, and stole his company. And that is why at the end of this trial, we'll ask you to return the only verdict consistent with the evidence required by law and demanded by justice. A verdict finding the defendant, Karen Beja, liable.
Thank you. From the defense?
Brief moment.
Certainly.
May I proceed?
You may.
I hate her. She took my dad away from me then, and she took my dad away from me on August 17th, 2012. I hope she is attacked and eaten by one of her tigers. Those were Cam Donaldson's thoughts. Those were Cam Donaldson's words. The plaintiff in today's case, Cam Donaldson, has been blinded by her hatred for her stepmother, Karen Beja. It's the hatred in those thoughts and words that explains why we're here today, members of the jury. Good afternoon. My name is Peter Calderola, and along with my co-counsel, Rebecca Fuller, we have the privilege of representing Karen Beja, a proud business owner right here in Pioneer Statesville. Karen, she's a mother of tigers. And to help you understand how Karen became a mother of tigers, we have to go back to the very beginning. Almost 20 years ago, Karen was out and down on her luck when she met her knight in shining armor. This man was Lou Donaldson. Lou and Karen fell madly in love, but you'll learn that Lou already had a family. This didn't stop Lou. In 2001, he marries Karen. And just before meeting her, he had started a company, Wild Wildlife. Now, Wild Wildlife was a rescue for big cats, tigers, lions, and the like. Karen and Lou devoted themselves to Wild Wildlife, devoted themselves to tigers just like this one, Tara. Tara was Lou and Karen's favorite tiger, just one of the many things that they shared together in their marriage. But you'll learn that Lou and Karen's marriage, it wasn't perfect. Just like any other marriage, it had its problems. You'll learn that Lou Donaldson had a mistress in Costa Rica. But Karen loved Lou. She was willing to try and work through this with him. However, on August 17th, 2012, Karen's life changed forever. Lou disappeared. And you'll learn that on that night of August 17th, 2012, and the early mornings of August 18th, 2012, Karen Beja was taking care of some tiger cubs that had just been, that were week old and had been rejected by their mother. In the early morning of August 18th, 2012, Karen leaves to go get some supplies that these tiger cubs desperately needed. On her way home, her car breaks down. So what does she do? She calls her brother, Carl Bannister, a deputy sheriff right here in Pioneer Statesville. You'll hear from Mr. Bannister's former testimony that he went and picked Miss Beja up and took her right back home to those tiger cubs who were waiting on her, waiting on the supplies that they needed. Now, ladies and gentlemen, you'll also hear about an investigation conducted by the Sheriff's Department here in Pioneer. After Lou's disappearance, the sheriff investigated, but what did they find? No body. And you'll learn they found no sign of struggle of blood. You'll hear that they even determined that there was no foul play involved in Lou's disappearance. That's not the only thing you'll learn today. You'll also learn that Lou Donaldson, he was an avid flyer. The plaintiff will even have to admit to you that her father bought and sold planes all the time, never properly registering them. You'll hear that he even had a suspended pilot's license. He wouldn't file flight logs sometimes. Karen will tell you that Lou would just get up and disappear, not telling anyone where he was going. Now, 5 years passed from August 17th, 2012. Karen waited and waited and waited until she couldn't wait anymore. And she did the only thing that she could. She filed for Lou Donaldson to be declared legally dead because she wanted the proceeds from the life insurance and she wanted the proceeds from the will all to go back to the dream her and Lou had built in Wild Wild Life. Karen will tell you she was going to use these proceeds to go right back into the business that her and her husband loved so much. Karen knew she needed to keep the dream alive. Now, we anticipate that the plaintiff will get up here and call a witness Taylor Pride. I want you to remember, members of the jury, that Mrs. Pride wasn't hired until 5 years after Lou Donaldson's disappearance in August of 2017, right when Karen was eligible to receive the proceeds of the life insurance and the will. You'll hear Mr. Pride, and we anticipate Mrs. Pride will tell you that in investigating this will, she thought it was a forgery. But members of the jury, we brought an expert of our own, Mr. Renard. And Mr. Renard will tell you that in the course of his investigation, working for Summit Life Insurance Company, not Miss Beja, that he found there was no reason to deny the insurance proceeds. And that his investigation of the will showed that that signature, it was genuine. It appeared to be genuine. At the close of today's trial, my co-counsel will get up before you and harmonize all the evidence you're going to hear. It'll be clear that the only answer the evidence points to is that Karen Beja is not liable. Cam Donaldson has been blinded by her hatred for Karen, her stepmother. I hate her. I hope she is attacked and eaten by one of her tigers. I want everything at Wild Wild Life, and I want all of the insurance proceeds. These were Cam Donaldson's thoughts. These were Cam Donaldson's words. Thank you.
Thank you. For the plaintiff, are you ready to call your first witness?
We are, Your Honor. Plaintiff calls Cam Donaldson to the stand.
Cam Donaldson, please take the stand. You are constructively sworn. Counsel, whenever you're ready.
Good evening. Please introduce yourself and tell us where you're from.
Good evening. My name is Cam Donaldson, and I'm from right here in Statesville.
Are you familiar with a man named Lou Donaldson?
Yes, he was my father. He passed away in 2012.
Your Honor, I have a photo of what appears to, well, the photo we showed in opening may be marked as Plaintiff Exhibit 1 for identification.
It can, sure.
Ms. Donaldson, do you have a copy of Exhibit 1?
I do.
And for identification, do you recognize it?
Yes, I do.
What is it?
It's a photo of my father and I when I was young.
Is Exhibit 1 in substantially the same condition as last time you saw it?
Yes.
Your Honor, plaintiff moves Exhibit 1 into evidence.
Is there any objection to Exhibit 1?
No objection, Your Honor.
All right, Exhibit 1 will be admitted.
Ms. Donaldson, were you able to spend a lot of time with your father?
Yes, almost every day for about 20 years, as I worked as his assistant at Wild Wildlife.
What kind of work did you do with your father?
I did everything from answering phones to scheduling meetings, writing checks. I ran the books. My father would often joke that I knew more about the business than he did.
Do you miss your father?
Yes, I miss him every single day.
Now, at the time you last saw your father, was he married?
Yes, to the defendant, Karen Baja.
Now, I want to talk to you for a minute about your father's relationship with the defendant. Did you ever see the two of them together?
Yes, we all worked together at Wild Wildlife for many years.
Based on your own personal observation over those many years, how would you describe their relationship?
Not good.
Why would you say it was not good?
Well, I heard them argue frequently.
When was the last time you heard them argue?
In the weeks leading up to my father's, the time he was last seen, I heard them arguing at the office.
Can you tell us what you saw during that last argument at the office?
Well, I heard them arguing, and then Karen stormed out and my father came out of his office.
What was your father's demeanor when he came out of the office?
Visibly shaken. I had never seen him like that before. And then he excitedly uttered to me, if anything ever happened to me, have the police look into Miss Baja because she will be the one who caused my death.
Objection, Your Honor. This testimony is hearsay. Under Rule.
Counsel, your response to hearsay.
Your Honor, this falls under the exception to hearsay under the excited utterance 8032.
Counsel, do you have another response?
Yes,
Mr. Calderon.
Yes, Your Honor. This is not an exception, as it is not an excited utterance. There was a attenuation of time from when this statement, when this argument had happened, and from Mr. Donaldson leaving that argument and moving away from it. There was too much attenuation, Your Honor.
Any other response, Mr. Mays?
Your Honor, I can lay the foundation as to the timing of when this statement was said.
If you'd like to do that, that'd be great. All right, so I'll sustain the objection for now, and if you're going to lay some more foundation.
Ms. Donaldson, how passionate was that argument between your father and the defendant that you saw?
It was heated. I heard them shouting. They were arguing.
And how was your father's demeanor when you saw him?
Like I said, he was just visibly shaken. I'd never seen him look that way before.
And how soon after that argument did you speak with him?
Immediately after.
And what did he say to you when you saw him immediately after?
He said that if anything should ever happen to him, to have the police look into Karen because she would be the one that caused his death.
When was the last time you saw your father?
August 17th, 2012 at around 6 p.m. on a Friday.
What happened when you saw your father at 6 p.m.?
Well, as he was leaving, he said that he invited me over for dinner that Sunday. And if I didn't come, that I would see him Monday.
So that was on a Friday. When was the next time you went into the Wild Wildlife?
Well, I actually had to go there on Sunday.
On a Sunday? Why'd you go there on a Sunday?
It was around 6 a.m. when the alarm went off. So I went down there to see if everything was okay.
What'd you see when you got down there?
Well, I got there just as the police were arriving, and I saw that the padlock on the chain had been cut and that the back gate entrance was completely destroyed.
Besides the police, did you see anybody else there?
Yes, I saw the defendant, and she was carrying a lockbox from my desk and also a sketchy looking man with lock cutters.
What was in that lockbox from your desk?
It's my father's will.
Your Honor, I have a photo of what appears to be a broken fence, maybe marked as Plaintiff Exhibit 2 for identification.
Certainly.
And-
Exhibit 2.
Yes, and this item can be found, it's labeled as Donaldson Deposition Exhibit 3 following the deposition.
Of course,
Miss-
familiar with it.
Ms. Donaldson, do you have a copy of Exhibit 2?
Yes, I do.
Directing you to that exhibit, do you recognize it?
Yes.
What is it?
It's the damaged back gate at the time of the break-in.
Now, is Exhibit 2 a fair and accurate depiction of that back fence on the way it was on Sunday, August 19th?
Yes, it was.
Your Honor, plaintiff moves Exhibit 2 in evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 2 will be admitted.
May I publish Exhibit 2 for the jury?
You may.
Ms. Donaldson, do you see your screen?
Yes, I can.
So is this the back entrance to your office that you were talking about?
Yes, this is the back entrance.
And your desk where that lockbox was kept, that was in this office?
Yes, it was.
Okay, so after the break-in on Sunday, when was the next time you went to work?
It was Monday, the next day.
And are you still working at the Wild Wildlife?
No, the defendant fired me.
Okay, I want to go back and talk about that will and that lockbox that was kept in your desk. How did that will that was in that lockbox divvy up your father's assets?
It split it up 4 ways. So 25% went to my mother, 25% to me, 25% would go to a foundation to keep Wild Wildlife running, and then only 25% went to the defendant.
At some point, did the defendant present a will?
Yes, she did. About 2 weeks after.
And was that will the defendant presented the same as that will that was in your lockbox?
Absolutely not.
How was it different?
It left everything to her.
Your Honor, no further questions at this time.
All right, cross-examination.
Yes, Your Honor. Brief moment to prepare the will.
Granted.
Thank you. May I proceed, Your Honor?
You may.
Good afternoon, Ms. Donaldson. I'd like to talk a little bit about your lawsuit today. You say that Karen only cared about your dad for money, money, money.
Yes, that's true.
But you're suing Ms. Beja, aren't you?
Yes, counsel.
You're suing Ms. Beja to get the proceeds of the life insurance policy, correct?
Correct.
And that's worth $5 million?
Correct.
And you're also suing to get the proceeds of the will, correct?
Yes.
That's also worth $5 million.
Yes, it is.
So you're asking this jury today for $10 million.
Yes, I am.
You're telling this jury you deserve that $10 million.
Yes, I am.
Now I want to move on to your aspirations at Wild Wildlife. You did everything at that business, didn't you?
Yes, like I said, I ran the books, answered phones, scheduled meetings, wrote checks. I did the business side of things.
You answered phones,
Correct.
scheduled the meetings,
Correct.
ordered supplies.
Yes.
You were in this position as an assistant, correct?
Correct. I was my father's assistant.
But you were never promoted in the 20 years that you worked there.
No, I was his assistant. I ran the business, like I just said.
That's right. You were also never given any ownership interest over those 20 years as an assistant, right?
No, I wasn't.
Now, I'd like to talk a little bit about the night you say Karen broke into the business. Karen was married to your father, wasn't she?
Yes, she was.
So that would make her a part owner of Wild Wildlife?
No, she was not a part owner. My father owned that business.
Well, if Miss Beja was a part owner, somebody doesn't break into their own business, do they?
Well, she wasn't a part owner of this business. My father owned it.
She helped build it up with your father, didn't she?
To my knowledge, she worked there, but she was not a part owner.
Cam, I want to move on. Miss Donaldson, I'd like to move on to your relationship with your father. You say you were close with your father?
Yes, I was very close with my father.
You knew the ins and outs of his life?
Yes, I did.
You knew that his passion was always for tigers.
Yes, that was his life's work.
Another one of his hobbies was that he liked to fly planes.
Yes,
Always buying and selling them,
yes,
never properly registering them.
yes, he didn't register some planes.
Sometimes he would just take off without filing any flight logs, right?
Correct, but he would always tell me when he was leaving.
But there were no flight logs, correct?
To my knowledge, there were no flight logs for some flights.
Your dad's pilot's license, it was even suspended, wasn't it?
Yes, it was.
And you know that there's 2,200 miles from Statesville to Costa Rica, right?
Objection, Lex Foundation.
Counsel, your response.
Yes, Your Honor. This has been stipulated to that all witnesses are aware of this fact. Brief moment while I refer to the record.
Your Honor, withdrawn.
All right, then that's withdrawn. You may, if you'd like to ask the question again, you may.
Yes, Your Honor. Ms. Donaldson, you know that there are 2,200 miles between Statesville and Costa Rica, don't you?
That's correct.
But you're sure it's not even possible your dad's somewhere along those 2,200 miles, right?
Objection,
No.
speculation.
Counsel, your response to the speculation objection.
Your Honor, I wasn't asking whether or not the witness knew if Mr. Donaldson was in fact there or not. I was just asking if it was a possibility.
I'm going to overrule the objection. I believe that this within this witness's knowledge. So overruled. You may proceed.
Yes, Your Honor. So, Ms. Donaldson, you're sure that's not even a possibility that your dad's somewhere along those 2,200 miles, right?
No, your client killed my father.
Well, that's right. Let's talk about your belief that my client killed your father. The police investigated this, didn't they?
Yes, they did.
The police didn't find any body.
No, they didn't find a body.
They didn't find any sign of blood.
To my knowledge, they did not.
No sign of struggle, right?
I'm not sure.
Well, they didn't suspect any foul play, did they?
No, they didn't. They turned a blind eye.
This makes you angry that they turned this blind eye, right?
Yes.
But you didn't go searching for your dad in 2012, did you? When he disappeared?
No, I did not.
You didn't go searching for him in 2013?
No.
Not in 2014, right?
No, counsel.
In fact, it wasn't until August of 2017 that you hired Investigator Pride to search for your dad, right?
That's when I hired him.
And Investigator Pride, he couldn't find your dad, could he?
No, he couldn't.
And you're not out there right now still searching for your dad, are you?
I'm sorry, counsel, you cut out on that last little bit. I missed what you said, sorry.
Repeat the question, Ms. Donaldson. You're not out there still searching for your dad, are you?
Objection, relevance.
Counsel, your response to relevance.
Yes, Your Honor. As part of damages in today's case, the plaintiff is asking for consortium damages as the relationship of her and her father. It would only be clear, it would be clear to anyone that in seeking consortium damage, you would want some closure on where your father is. This is extremely relevant to today's case. As Your Honor knows, relevance is a very low bar.
Any response, Mr. Mays?
With regards to the relevance, I don't see how what his Cam is doing today has to do with the damages she's felt throughout this whole period.
I'm going to overrule the objection. I believe that it is relevant because the damages would take into account not only this point, but also for the future as well. So the objection's overruled.
I'll repeat my question, Ms. Donaldson. You're not still out searching for your father today, even though Investigator Pride couldn't find him, are you?
I'm searching for justice for my father today.
That wasn't my question, Ms. Donaldson. I'm going to direct you back to my question. You're not still out searching for your father, are you?
Like I said, I'm searching for justice for my father. Your client had killed him.
So was that a yes? You're not searching for your father anymore?
Correct, because he's dead.
Instead, you're here in court today suing Ms. Beja, aren't you?
Yes, I am.
Let's talk about your hatred for Ms. Beja. You don't like Karen, do you?
Absolutely not. She murdered my father.
You haven't liked her since the day you met her.
No, I don't like her.
In fact, shortly after your dad met her, he married her.
Yes, that's true.
Left your mom.
Yes.
And you don't like Ms. Beja for replacing your mom, do you?
No, I don't.
You hope that Ms. Beja is attacked and eaten by one of her tigers, right?
Yes, she murdered my father. I don't like her.
You hate her.
Yes.
No further questions, Your Honor. Pass witness.
And redirect.
Yes, Your Honor. Ms. Donaldson, on cross, counsel talked about your father possibly flying to Costa Rica. Did your father ever share his trips with you?
Yes, he always told me when he was going out of town.
And when you spoke with him and saw him on that Friday, August 17th, did he say anything about going out of town?
No, he didn't.
No further questions, Your Honor. May this witness be excused.
Witness may be excused.
Your Honor, brief moment while I switch out with co-counsel.
Certainly.
Thank you.
All right, from the plaintiff, are you ready to call your next witness?
Yes, Your Honor, but prior to calling our next witness, we would first like to read in a portion of a deposition from an unavailable witness in this case. We would like to read in a portion of Carl Bannister's deposition, which can be found using the virtual PDF document, pages 32 to 36. He's been stipulated by both parties as an unavailable witness today.
All right. And how are you going to read? Are you just going to read it question and answer, or are you going to use co-counsel? How is this necessarily going to take place?
Yes, Your Honor, my co-counsel and I would like to read in portions using the question and answer format.
All right, you may proceed.
Your Honor, would you like me to instruct the jury on what an unavailable witness is, or would you like to?
That's fine. I'll do that with jury instructions at the end. We may proceed.
Okay. Have a brief moment, Your Honor.
Certainly.
Question. Are you aware that the Pioneer Sheriff's County Office keeps tracking records for all vehicles?
Sure, it is a good way to know where each deputy is located in the jurisdiction during a shift.
Are you also aware that there is no record of your patrol vehicle moving from 328?
Hearsay.
Is it an objection?
Yes.
Objection to hearsay? Counsel, your response?
Your Honor, both parties have stipulated that this is an unavailable witness under Federal Rule of Evidence 804A.
And counsel, your response from Ms. Fuller?
Yes, Your Honor, we do not object to the statements of the deposition itself. We object to what is the information contained within this question and answer. if we may be heard outside the presence of the jury constructively.
Constructively, yes.
The response, or the question and answer, actually refer to a record of a transponder on a police vehicle, and that record, the contents of it is hearsay.
Response, counsel.
Your Honor, we're not introducing the record itself. This witness in the deposition has testified to his own personal knowledge and that he's aware his police vehicle is being recorded using a transponder system, and that he's aware it was offline within the time that it's alleged he was with the defendant in this case.
Your Honor, if I may respond.
Last one, yes.
Yes, the knowledge, he's testifying to the hearsay statements that were within that report. So the statement, him testifying to it, is still hearsay.
Counsel, I disagree. They're not trying to enter that document, so I'm going to overrule the objection. You may proceed, and if you don't mind, ask the question again, please.
Yes, Your Honor. Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m., as it was showing it was near the grocery store close to Ms. Baugia's home during that time?
Yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was replaced the next day.
Thank you. Your Honor, that concludes the reading of the portions we would like from Carl Bannister.
All right. What I'd like to do is give an opportunity to the other side at this time to do it as a quote unquote cross-examination. Ms. Fuller, did you want to read in anything from the witness, Deputy Bannister, at this time?
Yes, Your Honor. We would like to do that if we could do it in question and answer format with my co-counsel.
Certainly.
Your Honor, prior to the reading of their portion of Carl Bannister, we would ask that this time specifically be counted towards their case in chief.
It will.
So we will begin the reading, if we may proceed, Your Honor.
You may.
We'll begin on the first page of the deposition, line 1. Hello, Deputy Bannister. Would you please state your name and spell it for the record?
Deputy Carl Bannister, that's CarlBannister.
What do you do for a living?
I'm a deputy sheriff for Pioneer County, Statesville.
We will end at line 4 on the first page of the deposition, begin again at line 8 on that first page. How are you involved in this case?
Well, I'm not involved in the case, but I guess you can say I'm here because my sister is Karen Beja.
So ending at line 10 on the first page, beginning again at line 16. Okay, let me ask you about the night, early morning hours of August 18th, 2012. Do you remember that pre-dawn time?
Yes, I do.
How do you remember it?
I was on duty that night, graveyard shift, so from 12 a.m. to 8 a.m.
What do you remember about that time?
Well, it was a normal sort of shift. I was just answering patrol calls when I got a personal call from Karen.
When was that?
It was close to 3 a.m. She had gone out to the grocery store late at night in order to get some milk or something for some newborn tiger cubs. She had trouble and needed a ride home as soon as possible to get back to the cubs.
Did you go to pick her up?
Yes, I did.
Did you use your patrol car?
Yes, she was actually in my patrol area.
When did you pick her up?
Well, I was just finishing the paperwork on a DUI arrest, so it took me just a few minutes. I wrapped up what I was doing and met up with her around 3:20 a.m. or so.
So you were very close to her location?
Yeah, I guess.
Where did you meet with her?
Her car was on the side of the road a couple of blocks away from the grocery store.
How close was this to her home?
A couple of miles at most.
Was she going to or coming back from the grocery store?
I believe she was coming back as she had some groceries with her.
How was she doing when you met up with her?
She was fine. She was just really concerned about those newborn cubs and wanted to get back to them as soon as possible.
Did you drive back to her home?
I first took a look at her car and it would not start. So I made sure it was safe by the side of the road and then took her home. We got to her house around 3:45 a.m., definitely before 4 a.m.
ending on line 24 of the second page of the deposition, and we'll begin again on page 4 of the deposition at line 10. Question, were you involved in the investigation of the disappearance of Lou Donaldson?
No, it would not have been appropriate. I mean, I know the detectives and investigators who looked into it. I have been working with them for years, and we're all pretty close, but I was not personally involved in the investigation.
Did you have a chance to view any evidence or look at the reports?
No, I take my job seriously. I knew nothing of Lou's disappearance, and I wanted to keep it that way. I was walled off from the investigation. That was fine by me.
This concludes our reading of the portions of the deposition we would like in, Your Honor.
All right.
Your Honor, at this time, pursuant to your ruling in motion in limine, we would like for the video of Exotic Bob to be admitted into evidence as Plaintiff Exhibit 3.
All right. Plaintiff's Exhibit 3.
May that be shown at this time for the jury.
Is there an objection?
Your Honor, we would just like to renew our objection for the record on appeal to this video, as it is inadmissible hearsay and also more prejudicial than probative under Rule 403.
All right. Your record has been made, counsel. Thank you.
Thank you.
And you may proceed. We will enter based on the pretrial ruling for Exhibit 3 that will be entered. And if you would like to publish that to the jury, you may.
Thank you, Your Honor.
Hey, the cat sister, where you put your mister? Feed a little lion's den. Hey, the cat sister, where you put your mister? Feed a little lion's den. Hey there, I'm Exotic Bob. You probably recognize me as the owner of the world famous leopard camp, I See Spots. I want to thank you for your patronage over all these years. I'm currently a guest of the federal maximum security hotel system. Compliments of one Karen Baja, and that's who I'm here to talk to you about today. You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. We was illegally importing leopards and lions. Leopards was for her, leopards was for me, lions was for her. Now, we never worked together before, and we never worked together since. But due to the severe illegality of the deal, we thought it best to work together, so we did. And at the end of that meeting, Karen Baja walked out of my office. She stopped, suddenly turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye, and she said, Exotic Bob? That's me, Exotic Bob. She said, Exotic Bob, I swear if you double-cross me on this deal, I will do to you exactly as I did to my husband. She said, there won't be no disappearance, no mythical flight to Costa Rica. She goes, your last supper will be you. I'll feed you to my kiddies just like I did him. And then she turned around and she walked out of my office. That's all I've got to say about that. Hey there, evil woman, where you think you're going? We all know where you've been. Hey there, evil woman, where you think you're going? We all know where you've been.
Your Honor, at this time, plaintiffs call Taylor Pride to the stand.
Taylor Pride, please take the stand. You are constructively sworn. Counsel, you may begin when you're ready.
Good evening. Please introduce yourself to the jury and tell us what you do for a living.
Good evening. My name is Taylor Pride, and I am a forensic document examiner. I actually have my own firm called Pride Investigations, Inc.
What do you do as a forensics document examiner?
Well, I'm hired to investigate cases and analyze the authenticity of various documents using forensics.
You mentioned you own your own firm. When did you open it?
I believe it was in 2016 after I left the Pioneer Police Department.
Let's actually talk for a little bit about your time at the police department. Were you an officer there?
I was a patrol officer when I started in 1998, and then after about 2 years, I was promoted to detective.
What were your duties as a detective?
I investigated a variety of cases, anything from economic crimes all the way to homicide.
How long were you a detective in the police department?
I know this is really going to age me, but I was there for about 16 years.
Did you investigate any forgeries throughout your time there?
Yes, I investigated a lot of forgeries during my time there.
Are you currently certified?
Yes, I am.
Have you ever testified as an expert in court before?
I have, and I've testified on both sides of the cases, and it's been about 15 times now that I've been entered as an expert.
Your Honor, at this time, plaintiffs tender Ms. Pride as an expert in handwriting analysis and investigation.
Any objection?
Your Honor, the defense has no objection to Ms. Pride giving her opinion on the handwriting analysis portion of her report. However, we would object if we may be heard constructively outside the presence of the jury.
Certainly.
We would object to any opinion that she may have as to how Lou Donaldson disappeared or that Karen Beja caused his death specifically. If we may take this witness on a brief voir dire to demonstrate that she's qualified to give an opinion on that.
Certainly. You may proceed.
Ms. Pride, you mentioned before that you were a detective.
Yes, I was.
And as a detective, there are specific methods that are used in investigating things like disappearances.
Yes.
Or homicides.
Sure. Mm-hmm.
For example, you might use DNA analysis.
Yeah, that's possible that that's used in some types of cases and probably not in every case, but yes.
You might also use fingerprint analysis.
Yes.
You would also interview any suspects that you might have.
That's possible, yes, but that would be done in an investigation.
In this case, though, you came to an opinion that Karen Beja killed her husband, correct?
That's correct.
But you didn't base that on any DNA analysis.
Not every investigation has every component. It's not like you see on the TV shows and CSI and things like that. Sometimes you look at circumstantial evidence, like how outrageous it would be that somebody goes to Costa Rica and doesn't tell anybody about it or doesn't spend any money. And just all these different factors that the police department looked at, as well as myself during my investigation after I was hired.
You would agree, though, that you did not use any methods like DNA analysis or fingerprint analysis.
Unfortunately, the defendant did a good job of cleaning up after herself.
You also would agree that you didn't interview Miss Beja, who you believe to be responsible.
That's correct.
Your Honor, at this time, we would urge that this witness is not use appropriate methods under the federal rules of evidence to give an expert opinion on specifically what caused Lou Donaldson's disappearance.
It's a good objection to bring up because considering the tender is fairly broad, it's in for handwriting and just the general investigation. I am going to allow the tender, so I'm going to overrule the objection, but it's certainly right for cross-examination based upon this particular tender. So with that, you may proceed, Ms. Jones.
Ms. Pride, turning your attention to today's case, how did you get involved?
Well, I was hired by Cam Donaldson in July of 2017 after her father had disappeared, and I was tasked with looking at the alleged last will and testament in this matter.
Did you also look into anything else throughout your investigation in this case?
Yes, I always want to make sure I'm looking holistically at everything, and so I collected bank statements. We looked at writing samples. We even sent an employee of mine all the way down to Costa Rica, and we wanted to touch base and look at various parties that had contact with Lou Donaldson, and that's when I was directed to the defendant in this case.
Why specifically did you look into the defendant?
Well, they had a history of marital problems, which was concerning. And, the number one motive, a tale as old as time, is finances. And she had a financial investment and gain as a result of Mr. Donaldson disappearing.
Ms. Pride, after conducting your investigation, did you reach an opinion in this case?
Yes, I did.
Do you hold that opinion to a reasonable degree of professional certainty?
I do.
What is that opinion?
It's my professional opinion that Ms. Baja killed her husband and that the will that is at issue in this case is fraudulent.
You also mentioned that you looked at some bank account statements earlier.
Yes.
Whose were those?
Those bank accounts belong to Lou Donaldson.
Your Honor, I have a copy of a document which appears to be bank statements, may be marked as Plaintiff Exhibit 4 for identification.
Certainly.
Directing you, Ms. Pride, do you have a copy of the exhibits in front of you?
I do, yes.
Yeah. Do you have what has been marked as Plaintiff Exhibit 4 for identification?
Yes, I do.
Do you recognize it?
I do, yes.
What is Plaintiff Exhibit 4?
That is the bank statement that I reviewed.
Is Exhibit 4 in substantially the same condition as it was when you last reviewed it?
Yes, it is.
Your Honor, at this time, plaintiffs move Exhibit 4 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 4 will be admitted.
Permission for my co-counsel to publish Exhibit 4 for the jury?
Granted.
Ms. Pride, what about this document was significant to your investigation?
Well, the thing that really caught my attention is the fact that Lou Donaldson deposited about $3,000 in cash into his account just days before he went missing. And then the account became inactive.
Why was that significant to your investigation?
Well, it really led me to believe at that point that there's no way he could have traveled out of the country to Costa Rica. For somebody to put that much cash in, it's unusual for us to not see any purchases in Costa Rica or any activity of any kind.
Thank you, Mr. Mays. You can take this down. Ms. Pride, you also mentioned that you analyzed the signature on a document. How did you analyze that signature?
Well, I like to look at a variety of things. And so I spoke to witnesses that were there for the signing of the will. I looked at various writing samples and I believe I just wanted
Oh, sorry. No, you're okay.
My apologies.
Your Honor, no worries. Your Honor, may we approach constructively to discuss a pretrial matter at this time? Your Honor, this witness is about to go into testimony regarding the restraining order document which you reserved ruling on. We would like to address that motion right now with the court before she testifies to it.
All right. Bringing up the temporary restraining order, is there an objection by the defense?
Yes, Your Honor. As we argued in the pretrial motion, this contents of this restraining order are more prejudicial than probative under Rule 403. Additionally, this is inadmissible character evidence under Rule 404B.
And counsel, your response? I know you've mentioned this before, but how are we there with the foundation for this particular witness to talk about this record?
Yes, Your Honor. This witness can testify that she specifically pulled and retrieved this restraining order for her investigation and that she relied on it throughout her investigation as well.
Now, when you say that she pulled it and relied upon it, what part did she pull and rely upon?
Yes, Your Honor. She retrieved this. This is an official state court public record, and she retrieved it and not only relied on the claims made throughout this. Specifically, if you would like, we can publish for the court to be able to read it. There are three claims
that's fine.
There are three claims on this restraining order, which go to the Lou Donaldson state of mind, and that factored into her analysis of whether the signature on Lou Donaldson's alleged will was authentic, specifically in that it was signed 48 hours before. So she considered whether his state of mind is likely that he would have not only been in fear and felt threatened and then signed everything he owned in a will to the defendant in this case.
Counsel, your response to that?
Yes, Your Honor. While opposing counsel argues that this is for the mindset of Lou Donaldson right before he was supposed to sign a will, there's too much danger here that the jury is going to use this as character evidence under Rule 404B. Instead of using it for determining whether the will is valid, there's a high degree of risk that the jury is going to use this in deciding whether Karen Beja had something to do with her husband's disappearance.
The temporary restraining order, I've had a lack of foundation for this particular document, and that concerns me. I understand that we've had some of the other information about the fights and the rest of it too, but just the temporary restraining order in itself, I am concerned about in allowing. I will allow it. If there's a signature comparison that was used for this particular document, I will allow that, that it can be talked about the court document. I am not going to allow in the temporary restraining order. I just believe that it's propensity evidence. You may go ahead.
May I be heard also briefly on that, Your Honor?
Certainly.
Your Honor, the defendant as well as Cam Donaldson will be able to testify and lay the foundation that a restraining order did exist. Any issues as to a potential propensity argument, we're more than willing for a limiting instruction to be issued to the jury that they're supposed to use this for the state of mind specifically. Nothing in this document will we be offering for the character of the defendant in this case.
It's well argued, counsel, and you can certainly bring this up on a cross-examination of the defendant should she choose to testify. But considering Cam Donaldson has already testified and this witness is the expert, my ruling stands. So I'm not going to allow in the temporary restraining order at this time unless further information comes in and it basically opens the door. But at this point, I'm not going to let that in. I will allow the signature.
Yes, Your Honor. So just for clarification, may this be introduced later in a redacted form, just allowing the signature and the date so that way they can compare the jury?
Yes, that's fine. And it doesn't have to be officially redacted. It can be constructively redacted for this court's purposes.
Yes, Your Honor. We have a redacted copy available as well that we can publish for the jury.
Great. You may proceed.
Ms. Pride, shifting your attention, you said you analyzed the signature on the document. Can you please convey to the jury how you analyzed that signature?
Yes, as I was saying, I spoke to a witness, I collected various samples, and I looked at the specific language that was in the will.
Your Honor, I have two documents. One's a document that has been filed with the state court, and the second document is the alleged will that the defendant has presented. May these be marked as plaintiff exhibits 5 and 6 for identification?
Which one's 5 and which one's 6, counsel?
5 is a restraining order request and 6 is the alleged will.
All right. You may proceed.
Ms. Pride, directing you, do you have the exhibits in front of you?
Yes, I do.
Showing you exhibits 5 and 6 for identification. Do you recognize them?
Yes, I do.
What is exhibit 5?
That is the TRO, or the temporary restraining order.
And what is exhibit 6?
It's the alleged.
I believe that there was an objection. There must have been a sound issue for Ms. Fuller. Ms. Fuller, are you objecting? I saw you stand.
Yes, Your Honor. I'm sorry. Yes, I have an objection, Your Honor, to mentioning the title of the document in front of the jury when everything except for the signature and date has been redacted.
Counsel, without even necessarily getting into this, I would like to this referred to as a court document and without it necessarily being called the temporary restraining order. That would be conforming to my order and with the intent that I had just discussed. So I'm going to ask the jury to disregard any mention of a temporary restraining order. You are not to consider that. It is simply a court document that this expert necessarily relied upon. You may proceed.
Are exhibits 5 and 6 in substantially the same condition as they were when you last reviewed them?
Yes, they are.
Your Honor, at this time, plaintiffs move exhibit 5 and 6 into evidence.
Any objection to 5 or 6?
No objection, Your Honor.
All right. Considering the limitations on exhibit 5 and 6 are entered, and you may publish whenever you want.
Yes. Mr. Mays, can you please publish exhibits 5 and 6 for the jury? Ms. Pride, you mentioned that you spoke to one of the witnesses of this alleged will. Who
Yes.
did you speak to?
I spoke with Samantha Lane.
What did she say?
Well,
I believe there's an objection, but there is a little bit of a technical issue. So Ms. Fuller, I appreciate the fact that you're standing. I'll kind of keep an eye out for that.
Yeah.
There's an objection by Ms. Fuller. Ms. Fuller, go ahead and proceed.
Hearsay, Your Honor.
All right. Counsel, your response to hearsay.
Your Honor, experts are allowed to rely on hearsay pursuant to Federal Rule of Evidence 703.
Any response to that, Ms. Fuller?
Yes, Your Honor. Under Rule 703, while experts are permitted to rely on inadmissible evidence informing their opinions, that evidence is not admissible automatically because they relied upon it. Those facts cannot be disclosed to the jury just because the expert relied on them informing their opinion.
I'm going to give a little bit of latitude to this. You may, go ahead.
Oh, Your Honor, just I believe what opposing counsel is referencing is a reverse balancing test under 403. And we believe this information specifically from this witness is the probative value substantially outweighs the prejudicial effect, and that she is one of 2 witnesses to the will and the only witness without a financial stake in this case.
All right. We've heard a little bit of argument on this. I am going to go ahead and rule I'm going to overrule the objection. I'll give you a little bit of latitude on this, considering the expert witness and relying upon the information by Ms. Lane. Counsel, if you believe that there's other information or new information that comes up that is worthy of the objection, please feel free to do so. You may proceed.
Ms. Pride, when you spoke to Ms. Lane, what did she say?
She told me she did not, in fact, witness Lou Donaldson signing the will.
Did she say why she signed this document if she didn't see him actually sign it?
Yes, she told. Oh.
Objection, Your Honor.
Counsel, your objection?
Yes, to hearsay as before, and additionally under Rule 403, if I may be heard constructively outside the presence of the jury.
You may.
I anticipate the witness is about to say that Miss Lane said something to the effect that she was threatened that she would be fed to cats if she didn't basically lie in witnessing the will. Your Honor, this evidence would be more prejudicial than probative under Rule 403, in addition to the hearsay objection.
Any response, counsel?
Your Honor, again, this witness, Ms. Lane, is the only other witness without a personal financial stake. The only other witness to this document is the defendant herself, who is on trial for the authenticity and ulterior motives of killing Lou Donaldson. Her testimony is extremely probative in order for the jury to fully and accurately assess the credibility of this document.
Ms. Fuller, it's a good objection, but I'm going to overrule it. I will allow it, and it is ripe for cross-examination with this particular witness. You may proceed.
Ms. Pride, did Ms. Lane tell you why she signed as a witness if she didn't see Lou Donaldson sign this document? Oh, Ms. Pride, I believe you might be on mute.
My apologies. Yes. Miss Lane told me that she was frightened because she was threatened by the defendant. She said she would be fed to the cats if she didn't lie for her about this, about being a witness.
You also mentioned that you studied the language of this document. What did you learn?
What I can tell you is in reviewing hundreds of wills in my 23 years of experience, not one time have I seen a will say if I die or disappear. And so automatically that was a red flag for me.
You also analyzed the signature on this alleged will. How did you do that?
I collected various samples, I analyzed those samples, and I compared those samples.
What did you learn, and what did you learn from that comparison?
Well, I learned a couple things in making those comparisons. I used the signature first and foremost that was on the last will and testament that's in question.
What did you compare that signature to?
To the various documents that we've been discussing, and that includes the court document. I also looked at a driver's license and things like that to make my analysis.
And after you compared the signatures, what did you conclude?
My conclusion, based on my analysis of the signatures, and I can go in more detail about how I did that analysis, but ultimately that the signature was fraudulent and this was forged.
Can you please explain to the jury how you reached that conclusion?
Yes. So one of the things that really stood out to me was pen lifting.
What does pen lifting signify?
Sure. So when I'm looking at in comparison and making a comparison between two signatures, in this particular case, when we look at the last will and testament, it's clear that the person who was writing it lifted the pen more frequently than we saw Lou Donaldson do in the court document or his driver's license. And so that led me to believe that he was not the one who wrote the last will and testament for the pen lifting. But there was also issues with completing the letters in its entirety, as well as quivering.
Mr. Mays, can you take down the court document and zoom into the signature on the will for the jury? And you also just mentioned that you looked at every letter that was something that was assigned to you.
Yes.
What do you mean by that?
Well, in one of the documents, for example, there's a capital letter D, and the person who wrote that, there was two distinct strokes, as we can see here in this document. And so that's something that really caught my attention because Lou Donaldson and all of his other signatures that we know of does not do that. And he has a quickness and it shows kind of an attention for speed and looping. This person even wrote out the distinction of the lazy O and things like that. And so that caused me hesitation as well.
You also mentioned that there were quivering lines. What did you mean by that?
Well, I think, it's common sense when somebody's committing a forgery, they're looking and trying to compare and contrast and write at the same time when they're forging that signature. And so they're nervous and they're doing two things at once, and it causes that quivering motion that we can see here in this document.
And thank you, Mr. Mays. You can zoom out. Did you reach a conclusion regarding the authenticity of this document?
In my expert opinion, I believe that this is a forgery.
Thank you, Ms. Pride. No further questions, Your Honor.
All right. I know we've been going for a while. I intend to take a break if we'll do the cross-examination, and then we will take a 10-minute break. I just wanted to let people know at this point, just to have an idea. Ms. Fuller, your witness, cross-examination.
Thank you, Your Honor. Ms. Pride, I'd like to talk about what brings you here today. You no longer investigate crimes for law enforcement purposes, correct?
That's correct. I have my own firm now.
And you're hired by individuals to investigate.
That's correct.
In this case, you're being paid by the plaintiff, Cam Donaldson.
Yes, I do have to make a living.
To investigate the validity of her father's will.
Yes.
As well as to investigate her father's disappearance.
That's correct.
Lou Donaldson, Cam Donaldson's father, disappeared in 2012, correct?
That's my understanding, yes.
But you were not hired in 2012.
I was hired in July of 2017.
That's right. You were hired in July of 2017, which is nearly 5 years after Lou Donaldson disappeared.
Yes,
And it's only a month before Karen Beja filed for Lou Donaldson's life insurance policy.
that's correct. She was very quick to have him declared deceased.
I'd like to talk about where you think Lou Donaldson could be. You don't believe that he went to Costa Rica.
None of the evidence in my investigation suggests that that is where he is.
In part, you think that because his glasses were left here in Statesville, correct?
That's correct.
But you've never seen those glasses in person.
I don't believe so.
Objection, speculation.
So your response to speculation for this witness?
Yes, Your Honor, I would think that the witness would know whether she has seen the glasses in person or not, and would have knowledge of that.
The witness, objections overruled, the witness may answer.
You haven't seen these glasses in person.
I don't believe so, no.
In fact, you've only ever seen a photo of them.
That's correct. They're likely in police custody.
So you do not know what prescription the glasses are.
No,
You also sent someone to search for Lou Donaldson in Costa Rica, correct?
yes, I did.
You sent one employee.
That's correct.
One employee to search the entire country of Costa Rica.
Yes, I did, but it's still a matter of doing due diligence and doing what I could with the resources I had.
I'd like to talk about your opinion that the will was forged. You believe that Lou Donaldson's will that Ms. Beja inherited under was forged.
Yes,
And you base that opinion on the differences between Lou Donaldson's known signatures and the signature on the will.
correct. That's handwriting analysis.
But you would agree that no two signatures should ever be identical.
Correct, not identical, but there are significant characteristics that we can look to decipher which ones are real and which ones are fake.
In fact, if they were identical, that would be a sign of forgery.
That is true.
You also believe that Karen Beja is responsible for forging the will.
Yes,
But you didn't bother to compare any of Karen Beja's known handwriting to the allegedly forged signature.
well, when somebody's forging a signature, they are trying to mimic somebody else's handwriting, so it's nonsensical to try to look at her handwriting.
You prepared a report for today's case, correct?
That's correct.
You understood when you prepared that report that you had to be accurate,
Yes,
that you had to be truthful.
that's correct, counsel. I did not analyze that. I answered your question.
I'm sorry.
I did not collect her samples. I answered your question.
The explanation that you gave for the reason you didn't, that's the first time. Today is the first time you've ever given that explanation, correct?
Objection, Your Honor, improper impeachment. May we approach?
I'm going to overrule the objection. I believe this is proper. You may go ahead.
Your explanation that you gave for not comparing Karen Beja's handwriting to the allegedly forged signature, that's the first time you've given that explanation.
You asked me to explain why, counsel, so that was just an answer there, but that's correct. I did not put that in my statement.
I'd like to talk about Lou Donaldson's financial records. In forming your report for today's case, you pulled all of Lou Donaldson's financial records.
Yes,
When you prepared that report, you believed that Lou Donaldson never withdrew a cent after August 12, 2012.
that's correct. I believe that there was an activity after the money was deposited.
But you believe that the last activity, when you wrote your report, you believe the last activity was on August 12th, 2012, correct?
I believe that's what I said in my report. Yes,
And that belief was one of the facts that you based your report on,
yes,
that you based your opinion on.
That's correct.
Your Honor, we'd like to recall Plaintiff's Exhibit 4. May we publish Plaintiff's Exhibit 4, the bank statement, to the members of the jury?
Yes.
This bank statement, you reviewed this bank statement,
That's correct.
and it would be considered a part of Mr. Donaldson's financial records.
Yes.
You would agree that this final line shows that Lou Donaldson spent over $900 on August 17th, 2012.
It does appear that that's the case.
In fact, this statement shows 3 transactions after August 12th, 2012.
It does appear that that's the case, but 2 transactions after the deposit.
But there were 3 transactions after the date you said there were no more transactions, correct?
That's correct, but no transactions after that and for all since then.
So one of the facts you based your opinion on in this case was wrong.
I may have been mistaken by a couple days, yes.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Ms. Pride, you were just asked about Lou Donaldson's bank account statement that you reviewed. What day did Mr. Donaldson disappear?
I believe the 17th.
Were there any transactions on that bank account statement after the date of his disappearance?
No, and that's what was most concerning is there were no other withdrawals or deposits and nothing really since that time.
Thank you, Ms. Pride. No further questions, Your Honor.
All right, this witness
May
is
this witness be excused?
Yes. And we're going to go ahead and take a 10-minute break. I have 7:46 on my computer. Let's go ahead and if people are back early, let's start sharply, but I just want to make sure you have enough time to use the restroom, get a drink, whatever. So let's be ready to roll at 7:56.
Your Honor, at this time, can we get a brief time check, please?
We'll do a time check right as we come back. Okay, we'll give the witness, we'll get the scorekeepers or timekeepers, I'm sorry, an opportunity to get the time.
Thank you, Your Honor.
All right, we're on break. unmute. My computer just hit 7:56. If I believe that we have everybody still on. I see people logged on. Susan and Patrick, if you're ready. Susan, I think you're unmuted. If you're there.
Present.
Yeah, perfect. I'm here. And Patrick's here as well. Perfect. All right, then let's go ahead and get started. So we're now back in session, and are there any motions at this period in time?
Yes, Your Honor.
Record, plaintiff rests.
Oh, my apologies. Yes. So for the record, the plaintiff rests. Now, are there any motions?
Yes, Your Honor. The defense has one mid-trial motion. Before making that motion, Your Honor, we would ask for a time check.
Certainly. If we can talk to the timekeepers.
Yes, so for the plaintiff, they've used roughly 31 minutes.
Yes,
All right.
We would like to move forward with our mid-trial motion.
And for the defense?
The defense has used about 23 minutes.
Okay.
And Your Honor, just as a housekeeping question, are we supposed to be timing the halftime motion as well?
I think we're fine to go ahead and do so. Sure, let's go ahead and time it, but I don't think it'll take that long. That's fine.
And I'm sorry, Your Honor, I had misunderstood when you were asking for the plaintiff's time. So the defense has only used 23 minutes. Is that correct, timekeeper? I'm sorry.
Yes, sir.
Okay, thank you. We would
All
like
right.
to mid-trial motion.
Certainly, you may proceed.
Yes, Your Honor, thank you. Your Honor, pursuant to Rule 50 of the Federal Rules of Civil Procedure, the defense would like to move for a motion as a judgment as a matter of law, as no reasonable juror or jury could find that Ms. Beja was in fact involved in her husband's disappearance. The plaintiff had to prove today that Lou Dalton was dead, that death was caused by the intentional reckless conduct of Ms. Beja, that Cam Dalton suffered damages, and further that those damages are the result of that intentional reckless conduct by Ms. Beja. The plaintiff fails here simply because they can't prove the first element. They can't prove that Lou Dalton is dead. Although Ms. Beja did have Lou Dalton legally declared dead, there has been no body, there has been no evidence of blood or foul play, and the police thoroughly investigated this claim. Because of that, Your Honor, we would urge that as a judgment of a matter of law, we ask this court to dismiss this case.
All right, response?
Your Honor, we have provided significant circumstantial evidence which shows that Ms. Beja intentionally caused the death of her husband. Specifically, we heard from Cam Donaldson, who told us that prior to her father disappearing, that she informed him that if anything should happen to him, look into the defendant. We also heard evidence from two individuals. We heard from Bob Exotic, who received a threat from Karen Beja, and Miss Lane, who also received a threat from Miss Beja. With regards to the will's validity, Miss Lane was one of the two witnesses to that will. And she stated that she was coerced into signing that will and was threatened by the defendant. Additionally, our expert concluded that this will was forged, and this evidence is more than sufficient for a reasonable jury to conclude that Miss Beja was involved in her husband's killing. And for that reason, we respectfully ask the court to deny this motion.
All right. The motion is denied. And so we will go ahead and proceed at this point with the defense case in chief. And you may call your first witness.
Yes, Your Honor. The defense now calls Mr. Chris Renard to the stand.
All right. Mr. Chris Renard, you may take the stand. You are constructively sworn. Counsel, whenever you're ready.
Yes, Your Honor. Thank you. Good afternoon, Mr. Renard. Please take a second to introduce yourself to the members of the jury.
Yeah, so my name is Chris Renard, and my last name is spelled Renard. And I live here in Pioneer, Statesville.
What do you do for work here in Pioneer, Mr. Renard?
I work as an insurance claim investigator.
Who do you work for?
I work for Summit Life Insurance Company.
How long have you been working for Summit Life Insurance Company?
I've been working for them for about 20 years.
What are your specific duties as
a life insurance claim investigator?
So I do a lot of things in my job. I mean, obviously, I review insurance claims. That's my main responsibility, to determine if any fraud has taken place, and just determining ultimately whether or not a beneficiary should be paid out. So while I'm doing these investigations, I conduct risk surveys to assess the loss. I collect and preserve critical evidence and documentation that might be relevant to my investigation. I conduct interviews. I just review incidents with the insurance claim and police reports, just to verify the veracity of the claims, make sure that there is no fraud involved.
Now, you said you're looking for fraud. How do you go about looking for fraud on documents?
Well, I am a forensic document examiner, and so I analyze these documents and determine their authenticity.
What do you mean by forensic?
So forensic meaning, like, I take these documents that are involved in any sort of transactional dispute between the company and the policyholder, or the beneficiary, or involved in court investigations.
How long have you been a forensic document examiner?
I've been a certified forensic document examiner for about 23 years and counting.
What was your educational background before going to work for Summit Life Insurance?
So I was trained for this sort of work at the Statesville Police Academy. I graduated from there in 1997, and I also have a Bachelor of Arts in Criminology that I got in 96.
Do you have any certifications in your field?
Yeah. I'm certified by the Board of Forensic Document Examiners, which is the national organization for my field, and also the Association of Certified Fraud Specialists.
How do you ensure that you stay current in your field?
So as part of the certification process, we have to to keep our certification current, we have to participate in annual training workshops and continuing education that's related to the field.
Tell us about your experience before going to work for Summit Life Insurance.
So immediately prior to my job with Summit Insurance, I was working for the Statesville Bureau of Investigations in their crime lab. I worked there from 97 to 2000. And then I left there to work for Summit. And then I've been that was in 2000. And I've been an investigator and forensic document examiner there ever since.
How did you get involved in today's case?
So I was contacted directly from our CEO at Summit. They had received a claim that was filed by the widow of the late Mr. Donaldson. He had a life insurance policy with us, and she was named the beneficiary. So our CEO thought that there might be fraud. I mean, it's a common thing that we do in every case, just to make sure the claim is legitimate. So our CEO asked me to investigate the claim.
During the course of your investigation, were you able to form an opinion about whether this policy should be paid?
Yes, I did.
Did you apply reliable principles and methods in forming your opinion?
Yeah, I did.
Are those the common types of reliable principles and methods used in your field?
Yes.
And do you believe that your testimony here in court today will help the members of the jury decide this case?
Yes, I believe it will.
Your Honor, the defense now tenders Chris Renard as an expert in life insurance claim investigation and also an expert in forensic document examination.
Any objection or voir dire?
No objections, Your Honor.
All right. Then the witness shall be tendered as the counsel put forth, which is insurance claim investigation and forensic document examination. Is that correct, counsel?
Life insurance claim investigation, Your Honor.
Life insurance. Okay. Life insurance claim investigation and forensic document examination. All right. The witness is tendered as an expert in those fields and accepted. You may proceed.
Yes, Your Honor. Mr. Renard, what did you review in coming to your conclusion for today's case?
So I reviewed a variety of evidence that I collected. I relied on information from a police investigation, and I also relied on some signatures that I had obtained to analyze against will that was provided with this claim.
I'd like to break that down a little bit, Mr. Renard. You first talked about some information you learned from a police investigation. Which police department are you referring to?
That would be the Pioneer County Sheriff's Office here in Statesville.
What did you learn from the Pioneer County Sheriff's Office here in Statesville?
Objection, Your Honor. May we approach?
Yes. Constructive approach.
Your Honor, we object. Improper expert opinion, lacks foundation, and hearsay.
All right, counsel, your response.
Your Honor, this witness has been tendered as an expert in life insurance claim investigation. To pay out these policies, these investigators commonly have to go and talk to police departments, figure out facts about surrounding a person's death or disappearance in order to determine whether or not that policy should be paid. This is exactly in this witness's purview, as he has for the past 20 years has looked into life insurance policies and the circumstances surrounding individuals' deaths.
Any other response, Ms. John?
Your Honor, this witness can testify as to the documents and information he relied on, but specifically in regards to the police testimony, he will not be able to lay the foundation as to who he spoke to. He will say he spoke to someone at the police department who works there. We don't know if they work as a janitor or if they work as an officer or a detective. He will not be able to name that contact, nor will we be able to authenticate the quality of that investigation, how thorough it was, who was spoke to, or the overall quality of it.
It's a good objection. I'm going to overrule. I'm going to allow the testimony. You certainly can bring up those points at cross-examination. Overruled. You may proceed.
Yes, Your Honor. Mr. Renard, what did you learn from the Pioneer County Sheriff Department?
So the main thing I learned was that the investigation into Mr. Donaldson's death was still open.
Why does an investigation being open matter to you?
Well, the investigation being open specifically into the death of the person who held the policy is a particularly important piece of information to have to see whether or not we should be paying out the beneficiary.
How long had this investigation been open?
At the time, it had been 5 years since Mr. Donaldson's disappearance.
And Mr. Renard, you also mentioned that you learned some other information from the police. What was that information?
So I also learned that Ms. Beja was not charged.
Your Honor, hearsay?
Counsel, your response to hearsay.
Yes, Your Honor. Under Federal Rule of Evidence 703, an expert is permitted to rely on inadmissible hearsay. And the second component of 703, Your Honor, is that its probative value in helping the jury evaluate the expert's opinion must substantially outweigh its prejudicial effect. This information is pertinent to Mr. Renard's analysis, as he relied exclusively on this information in order to determine that Ms. Beja should be paid the policy. The members of the jury would only be hurt by not being allowed to hear this kind of information.
Any response?
Your Honor, the prejudicial effect of this testimony outweighs the probative value. If we have a good faith belief, if allowed to testify, this witness will speak as to the police investigation, specifically an analysis of DNA evidence and other claims for the property. But again, since we do not know where this came from, the thoroughness of this investigation and the full brevity of it, we believe the 403 test is not met.
Overrule the objection. I'll allow it. You may proceed.
Yes, Your Honor. Mr. Renard, what was that other information that you learned?
So I learned that Ms. Beja was not charged or listed as a suspect on this particular investigation.
Now, why would Ms. Beja not being charged or listed as a suspect be important for your investigation?
Well, again, going back to the fact that it's been 5 years since Mr. Donaldson's disappearance, it was a significant fact in my determination.
What else, if anything, did you learn from the sheriff's department surrounding Lou Donaldson's disappearance?
So I did learn a couple other things. One thing was that Miss Beja had an alibi for part of the time period covering Mr. Donaldson's disappearance.
For those of us who don't know, what is an alibi?
So it's evidence that can be used to determine that a person was not at the scene of a crime or involved in a crime. If they had evidence that showed that they were somewhere else, a person can't be two places at once.
Why is the fact that Miss Beja had an alibi on the night of August 17th and early morning of August 18th, 2012 important to your investigation?
Well, like I said, a person can't be two places at once. So it leads you to believe that she wasn't involved in his disappearance.
Mr. Renard, what, if anything else, did the sheriff's department tell you about Mr. Donaldson's disappearance?
So I think one of the last things that I learned from them was that there was no blood or sign of a struggle found at the scene.
What does no sign of blood or struggle mean to your investigation?
Again, it just goes towards my ultimate determination. The police didn't see that there was foul play based on these facts. And so obviously that's really important for my determination on the policy.
After you reviewed all this information from the police concerning that Ms. Beja was never listed as a suspect or charged, that there was no foul play found by the police, and that Ms. Beja had an alibi, how did this affect your overall opinion?
So all of these facts, they did affect my opinion significantly because it made me determine that it was less likely that Ms. Beja committed this or was involved in the disappearance of Mr. Donaldson, and rather the other theory that Mr. Donaldson hastily left the country was more likely the correct scenario that happened here.
Mr. Renard, I'd like to move on to some other information you relied upon in your investigation. What's significant about the date August 17th, 2017, August 18th, 2017?
So that is the date that the claim was sent in. That was the date on the life insurance policy or claim, excuse me.
How many years had passed before that claim was filed?
So it actually was exactly 5 years after Mr. Donaldson disappeared. And it was also the first day that she could file based on the fact that she had to wait for a court to declare Mr. Donaldson legally deceased for her to file that claim.
Did Ms. Beja filing for that claim the very first day she was allowed concern you?
Well, sometimes that can raise a question for sure. When things like that happen, it could be seen as suspicious. In this case, it didn't, given a lot of the other evidence that I looked at, it didn't really affect my opinion.
Now, Mr. Renard, after Mr. Donaldson's disappearance, did you review any other documents?
Yes, I did review Mr. Lou Donaldson's will.
What about this will jumped out at you?
Well, one particular piece of the will did seem a little bit strange. The language specifically said that the estate and the life insurance policy would go to Ms. Beja upon Mr. Donaldson's death or disappearance.
Did this language cause you any concern?
I mean, again, I hadn't seen this before in my career, and I did look at it critically, but again, given the other information that I had, it didn't change my opinion.
Mr. Renard, I'd like to move on to your analysis of the signature on the will. What did you do in analyzing this signature?
Well, the first thing I did was obtain some known signature samples, so samples that we knew that Mr. Donaldson had signed previously, and then I took those samples and compared them to the signature on the will.
What samples did you collect?
So I got Mr. Donaldson's signature on file that we had at Summit from whenever he filled out the form for his life insurance policy back in 2005. And then I also obtained the signature copy from when Mr. Donaldson had applied to get a driver's license here in Statesville.
Recalling Plaintiff's Exhibit 6. May I publish to the members of the jury, Your Honor?
You may.
Mr. Renard, how did this analysis help you come to your final conclusion?
So as part of a forensic document examination, it's important to conduct a sample comparison like this. And so it was really important.
If I'm going to interrupt here for just a moment, this exhibit has not been entered. This is not exhibit number 6.
Oh, Your Honor, apologies. I had my sheet mismarked.
If we can just take the exhibit down, please.
Your Honor, can you please instruct the jury as to disregard this testimony?
I will, counsel. If we could just please get it off the screen.
Mr. Villarreal, if you could please remove it from the screen. I'll lay the proper foundation, Your Honor. I apologize.
Understood. My instruction to the jury is as follows. The exhibit that was placed up was mistakenly placed before you. That's exhibit was claimed to be exhibit 6. It was not exhibit 6. It's another exhibit. Counsel is going to lay foundation, and we may see or determine if that exhibit will be entered into evidence. At this point in time, the jury is to disregard that exhibit in its entirety, and will take it from that point. Mr. Calderola, if you'd like to proceed.
Thank you, Your Honor. Mr. Renard, directing opposing counsel in the court to what has been bait stamped as 007. Mr. Renard, do you have that document in front of you?
Yes, I do.
What is this document?
It is a signature comparison that I conducted using the samples I just discussed.
Do you recognize it?
Yes, I do.
And is it in the same or substantially same condition as when you prepared it or when you viewed it last before trial?
Yes.
Your Honor, defense now offers what has been bait stamped as 007 and marked as defense exhibit B for identification purposes only.
Okay, defense exhibit B.
Yes, Your Honor.
Is there, I'm sorry, counsel, are you entering that into evidence, or where are we at with this? You have it marked as that you're saying, are you going to be doing foundation with the witness, or where are we at?
Oh, I was laying foundation, Your Honor.
All right.
The process of laying that foundation.
Certainly, thank you. So that's, it'll be marked as exhibit B. The witness has it in front. You may proceed.
Your Honor, sorry to interrupt. For clarification, I believe this should be defense exhibit A.
Counsel, is that right? I wasn't sure if you were going to bounce it back and forth to another one.
Yes, Your Honor. I apologize. It is A.
Okay. All right. So for the record, that's not B. This is defense exhibit A, as this will be their first exhibit. And defense counsel is going to lay some foundation, and we'll proceed.
Yes, Your Honor. Do you recognize this document?
Yes, I do recognize the document.
How do you recognize this document?
I created it from the information that I gathered, the samples I gathered.
Is it in the same or substantially same condition as the last time you prepared or reviewed this document?
Yes, it is.
Your Honor, defense now offers what has been pre-marked as defense exhibit A into evidence as defense exhibit A.
All right. Is there any objection?
No objection, Your Honor.
All right. For defense exhibit A, that will be admitted, and you may publish whenever you like.
Thank you, Your Honor. Mr. Villarreal, will you please publish? Going back to this signature analysis, Mr. Renard, how did this analysis help you come to your conclusion?
So like I said, in comparing the confirmed signatures, the samples that I collected with the signature in question, which is the signature on the will that was submitted with the insurance claim, I was able to come to a conclusion that there were sufficient similarities.
You say there were sufficient similarities. Would you please point those out for the members of the jury?
Yeah, so the similarities that I found that were sufficient between the samples and the question signature was loops, the stroke direction, curves, legibility, angles, embellishment, and capitalization.
Did anything else catch your attention on this document?
There were some differences, but differences can be explained by multiple factors.
What factors help explain the differences in the signatures?
So a signature can change over time due to someone's age, due to their health, due to the care or speed at which they're signing, the instrument used, whether it was a ballpoint pen or an ink pen. It can change for all those reasons, or just because the person wanted to change their signature.
Did you do anything else to confirm this will's authenticity, Mr. Renard?
Yeah, I did. So there were two witnesses to the will. One was Miss Beja and one was Miss Samantha Lane. And so I contacted Miss Lane to confirm that she did witness the signature, and she did confirm to me over the phone that she did witness it.
After conducting your investigation of the signatures on this will, what was your overall opinion about Lou Donaldson's signature on the will?
So my overall opinion and my ultimate conclusion based on my investigation of the signature particularly was that there was insufficient evidence to rule it a forgery and that it did appear to be genuine.
Now, Mr. Renard, I'd like to talk about your final opinion for today's case. After reviewing the information you learned from the police, the information on the will, and the signature on the will, and all other relevant information, what was your final opinion regarding the payout of the insurance proceeds?
So regarding the insurance policy claim, that Ms. Beja was entitled to the insurance proceeds and that there wasn't grounds for Summit Insurance to contest payment.
Hypothetically speaking, Mr. Renard, had you or Summit Life Insurance Company found any sign of fraud, what would have happened?
Well, this was the whole point that the CEO asked me to be on this case, was to determine the fraud. And if fraud was found, that we wouldn't have paid out the policy to Ms. Beja.
What did happen in this case?
We paid out the policy, the $5 million to Ms. Beja.
Thank you, Your Honor. Pass the witness. No further questions.
All right, cross-examination.
Yes, Your Honor. May I proceed?
You may.
Mr. Renard, you're testifying here as an expert in forensics document examination.
Yes.
You reviewed the signature on Mr. Donaldson's alleged last will and testament.
Yes.
You reviewed that signature to determine whether it was authentic.
Yes.
In reviewing a document for its authenticity, you'd agree it's important to conduct a thorough analysis.
Yes.
It's important to consider all the evidence.
Of course.
And to approach the investigation without any biases or assumptions.
Yes.
Something that can indicate a will isn't authentic would be if one of the witnesses couldn't vouch for its authenticity.
Yeah, that would yes.
And you talked to Samantha Lane, one of the witnesses to Lou Donaldson's alleged will.
Yes.
And you also received a letter from Miss Lane.
Objection, Your Honor. I believe the question that counsel is getting into is an attempt to elicit hearsay testimony.
All right, counsel, your response.
Your Honor, pursuant to Federal Rule of Evidence 703, experts are allowed to rely on hearsay subject to a reverse 403 balancing test. This information the witness is about to testify to, the probative value, it substantially outweighs any prejudicial effect.
All right, counsel, any response?
Yes, Your Honor. Under 703, the witness must have relied upon this information. Here, this witness deliberately disregarded this information as he was not able to confirm or deny that this alleged letter from Mrs. Lane was in fact from Miss Lane.
I believe that's a good point for cross-examination. I'm going to overrule. You may proceed.
Mr. Renard, you also received a letter from Samantha Lane.
I wasn't sure if it was from Samantha or not.
But you would agree the signature and sign name at the bottom read Samantha Lane?
Yeah, it read Samantha Lane, yes.
And that letter also referenced a conversation, and you did meet with Samantha Lane in person, correct?
It was a while ago, but I'm pretty sure we talked on the phone. But I'm sorry, could you repeat your question?
Yes, sorry, my question maybe wasn't clear. You did speak to Samantha Lane,
Yes, I did.
and in the letter you received, she referenced a prior conversation with you.
I think so, yes.
Your Honor, I have a letter from Samantha Lane. May it be marked as Plaintiff Exhibit 7 for identification?
Yes, it'll be marked as Exhibit 7.
Mr. Renard, you have a copy of Plaintiff Exhibit 7 for identification?
Yes, I do.
You recognize it.
Yes, I do.
This is the letter you received,
Yes.
and this letter is in substantially the same condition as it was when you last received it.
Yes.
Your Honor, plaintiffs move Exhibit 7 into evidence.
Any objection to Exhibit 7?
Yes, Your Honor. We would object under 403 as this piece of evidence is substantially more prejudicial than it is probative, in that allowing the jury to see this would make them decide on an emotional response rather than a logical one, as the information presented in this letter was directly disregarded by Mr. Renard.
Any response, counsel?
Your Honor, this letter was received from one of two witnesses to the alleged will. The other witness is the defendant with other personal motives and biases for her testimony. Also, on direct, they already offered testimony from this witness that he spoke to Samantha Lane, refusing to offer the letter he also received and allowing the jury to assess his decision to completely disregard it in his overall analysis is substantially probative and necessary for the jury to assess the credibility of this expert witness's opinion.
I'm going to overrule the objection. I believe that we had a little bit of testimony about that. If I recall, I believe that counsel's correct. So with that regard, I believe the jury is allowed to consider it. So the objection's overruled and Exhibit 7 is entered.
Permission for my co-counsel to publish Exhibit 7 for the jury.
Granted.
Mr. Renard, you spoke with Ms. Lane?
On the phone, yes.
And she told you that Mr. Donaldson's signature on the will was authentic.
Yes, she did.
But shortly after that conversation, you received this letter?
Yes.
This letter says Ms. Lane was coerced into signing the alleged will.
Yeah, that's what it says.
And that she never saw Mr. Donaldson sign the alleged will.
Yeah, that's what it says, yeah.
That information directly contradicts what she told you when you last spoke.
Yes, it does.
According to you, this letter wasn't important to your analysis.
No, it wasn't.
In your words, it was a hoax.
Well, as far as I knew, I attempted to verify it, but I wasn't able to.
In your words, this letter was a hoax.
Yes.
And after receiving this letter, you contacted the defendant?
Yes.
You told the defendant about the letter you received from Ms. Lane?
Yes.
You told the defendant that there was an issue with the letter and Ms. Lane?
Yeah, I think I told her that there was an issue with the letter, yes.
But after that conversation with the defendant, you couldn't get in contact with Ms. Lane?
Yeah.
You tried to call her?
Yes.
But she didn't answer?
Nope.
In your words, it was as if she just vanished.
Well, yeah, as far as I know.
Well, in your words, it was as if Miss Lane just vanished, correct?
Sure.
Sure. Is that a yes?
Yes, ma'am.
Mr. Mays, you can take this down. Now I want to talk to you about the documents that you did consider in your investigation. You reviewed the signature on the alleged will.
Yes.
And you compared it to other known and verified signatures from Mr. Donaldson.
Yes, I did.
Your Honor, permission to publish what's been admitted into evidence as Defense Exhibit A.
All right. Exhibit A, go ahead and show that again.
Mr. Renard, this is your signature comparison form?
Yes, it is.
This first signature is from Lou Donaldson's life insurance paperwork.
Yes.
The second signature is from his driver's license.
Yes.
And the third signature is from the document the defendant presented as Mr. Donaldson's alleged will.
Yes.
And you don't know how old this driver's license signature is?
I don't recall.
It could be 2 years old.
It could be.
It could be 10 years old.
Yeah.
And the signature from the life insurance paperwork, that was from 2005?
Yes.
So it was 12 years old when you used it.
Yes.
And you'd agree there's some differences between these first two signatures and the one on the bottom?
Yes.
And in fact, there were enough differences that your overall finding as to the authenticity was inconclusive.
Well, I wouldn't say that.
Well, Mr. Mays, can you go ahead and zoom in on the bottom? In your words, there were also enough differences that the finding was inconclusive?
Oh, yes.
And you can't say for sure whether the signature on the will is either genuine or not genuine.
Well, it was inconclusive to not genuine.
So yes, you can't say whether the signature on the bottom is genuine or not genuine.
I can't say it's not genuine. That's what I've been saying.
Okay, Mr. Renner. And on direct, you mentioned that there are several reasons why a signature could be different.
Yes.
You said it could be because of someone's age.
Yes.
Could be because of the pen they used.
Yes.
Or it also could be because someone forged the signature.
Yeah, it could be.
And Your Honor, permission to publish for the jury what's already been admitted as Plaintiff Exhibit 6.
All right, Exhibit 6.
Also, Mr. Renner, on direct, you were asked about an alibi, correct?
Yes.
You testified that the defendant had an alibi for the evening in question,
Yeah, as far as I know.
and you remember writing a report for this case.
Yes.
At that time, you claimed the report was a full and complete analysis of your investigation.
Yes.
And nowhere in that report did you say that the defendant was with her brother for 40 minutes, correct?
No.
That was an opinion that you offered for the first time today?
Objection, Your Honor. Improper impeachment.
I'm going to overrule the objection. You may go ahead and ask the question.
Mr. Renner, that was an opinion you offered for the first time today, correct?
Offered?
Earlier on direct, you testified the defendant had an alibi for 40 minutes with her brother, correct?
Yes.
That is nowhere in your report you provided.
Yes.
So the answer to my question is yes. Today was the first time you offered that opinion.
Yes.
And Mr. Renner, this is the document you analyze as Mr. Donaldson's alleged will?
Yes.
And you're also aware, you were in court today when we talked about a court document that was filed just 2 days before this was allegedly signed?
Yes.
And you're aware that document had Lou Donaldson's signature?
I'm not sure if I am aware.
Well, that's right. You didn't consider it in your analysis of the authenticity of this will, right, Mr. Renner?
Yes.
And because you didn't consider it, you couldn't compare Mr. Donaldson's last available signature to the signature on this document.
Yes.
Even though that's his most recent one.
Well, I'm not sure if it's his most recent one or not.
Well, to be clear, the signature on that court document was dated June 12th, 2012.
I'm not sure.
Your Honor, permission for my co-counsel to publish what's been admitted into evidence as Plaintiff Exhibit 5. Mr. Renard, that signature, it reads June 12th, 2012,
Yes, it does.
and the signature on the will is June 14th, 2012.
Yes.
That would be a 2-day difference,
Yes.
but you didn't consider this signature.
No.
Mr. Mays, you can take this down. Permission for my co-counsel to republish the alleged will, which is Plaintiff Exhibit 6. And Mr. Renard, along with studying the signature on this document, you investigated the text of this document, correct?
Yes.
And you noticed there was some suspicious language in this document,
Yes.
specifically the phrase, "if I die or disappear."
Yes.
You've been in the industry for 23 years,
Yes.
looked at hundreds of wills,
Yeah.
and you never once have seen that language before.
I don't think so, no.
Well, in your words, you never once have seen that language.
No.
And that's also what you said on direct, correct?
Yes.
No further questions, Your Honor.
All right. Redirect.
May I proceed, Your Honor?
You may.
Mr. Renard, counsel spent a lot of time discussing Miss Lane. Why did you disregard this letter from Miss Lane?
So I had to disregard. I was forced to disregard it because I was unable to confirm the authenticity of the letter. I had a discussion with Miss Lane shortly before, and I attempted to call her and verify the authenticity, and I was unable to contact her.
Now, and also before coming to trial today, whose deposition testimonies did you review?
Whose deposition testimonies? I don't think I read any deposition testimonies.
You're familiar with Carl Bannister, are you not?
Oh, excuse me, yes.
And who was Miss Beja with the night she said she had an alibi?
She was with her brother.
Thank you. No further questions. May this witness be excused?
Yes. This witness is excused. All right, from the defense, your next witness.
Yes, Your Honor, brief moment.
Your Honor, the defense calls Ms. Karen Beja to the stand.
All right. Ms. Beja, please take the stand. And you are constructively sworn. Counsel, whenever you're ready.
Thank you, Your Honor. Good evening, Ms. Beja. Would you please introduce yourself to the members of the jury?
Yes, hello. My name is Karen Beja, and I am the owner of Wild Life, a company that I started with my husband, Lou Donaldson.
I'd like to come back and talk about your business more in a little bit, but first I'd like to talk about your husband. How did you meet your husband?
It's actually kind of a funny story. I was hitchhiking one night, and Lou happened to be the one who picked me up. We spent that night together and never looked back. I guess you could say he was like my knight in shining armor.
How would you describe your husband?
Lou and I were both very passionate about advocating for animals, and that was something that we shared together. But, you know, Lou was a bit of a loner sometimes. He had some interests and hobbies that he didn't always share with me.
What interests were those?
For example, he loved to fish. He did that by himself. He was also a pilot, so he would take trips and, you know, fly his planes, and he did that primarily alone as well.
Do you have any idea where he would go?
I know one of his favorite destinations was Costa Rica. He went there quite often.
As far as you know, why would he go to Costa Rica?
I actually learned that one of the main reasons he was going so often was because he had a mistress down there.
How did you respond to that, Ms. Beja?
It's not something that any wife ever wants to hear or even have to deal with. But Lou and I spoke about it, we talked about it, and we were working on our marriage.
Was there ever any talk of divorce?
Yes, Lou did mention it once, but like I said, we were working on our marriage. No marriage is perfect.
As far as you know, Ms. Beja, did anyone ever accompany Lou Donaldson on these trips to Costa Rica?
No, as far as I know, as far as I know, he took those trips alone.
Did he keep a record of where he was going?
No, Lou's pilot's license had actually been suspended. So when he would take these trips, he didn't file flight logs because he wanted to stay off people's radar because of that suspension.
Now I'd like to go back and talk about the business you mentioned that you started with your husband. What is Wild Wildlife?
Wild Wildlife is an animal sanctuary for big cats. It's a place for them to feel safe and be protected.
For those of us who aren't familiar, what is a big cat?
So a big cat is an animal like a lion, a leopard, tiger, things like that.
I'm directing the court and opposing counsel and the witness to what has been marked with Bates number 009 for identification purposes. Your Honor, at this time, we'd like to mark this exhibit as Defense Exhibit B.
All right, Exhibit B.
Ms. Beja, have you located the exhibit?
Yes, I have.
Do you recognize this exhibit?
Yes, I do.
How do you recognize it?
This is a photo of Tara, a big cat at Wild Wildlife.
And is this a fair and accurate depiction of Tara?
Yes, it is.
Your Honor, at this time, we offer what has been marked as Defense Exhibit B into evidence as Defense Exhibit B.
Any objection?
No, Your Honor.
All right, Exhibit B will be admitted, and you may publish whenever you like.
Thank you, Your Honor. Tell us about Tara, Ms. Beja.
Sure. So Tara was
Relevant.
Counsel, your response to relevance.
Yes, Your Honor. This is to give context. In this case, the defendant owned this business with her husband, and I'm sorry. This is relevant to the defendant's relationship with her husband. In this case, the plaintiff alleges that Ms. Beja caused her husband's death, and this question disproves that fact or that claim.
I'm going to overrule the objection. Counsel, you just did not object to this exhibit coming in, and then when questions were asked about it, you did raise a relevance objection. I don't want to go down some sort of rabbit hole related to this, but I will give you a little latitude. So the objection's overruled, and if you want to re-raise the objection at some point, if we feel we're going astray, Mr. Mays, you may do so. You may proceed.
Ms. Beja, would you please tell us about Tara?
Sure. So Tara, like I said, was Lou and I's favorite cat at Wild Wildlife. Basically, the reason we started Wild Wildlife is to create a safe place for animals like Tara who are desperately in need of protection, and that's why we did it.
What does caring for a big cat like Tara entail?
It's actually a lot of work. I don't know if people realize how much. The night that Lou disappeared, I was actually caring for some tiger cubs that, had just been born and been rejected by their mother.
Eddie, if you would stop sharing the screen, please. I'd like to go through what happened that night, Ms. Beja. Could you tell us what exactly was going on with the tiger cubs?
Sure. So they had been born about a week earlier, and it was an unfortunate situation where the mother rejected them. What happens then is they have to be given milk and formula by me in order for them to survive. That's not something I always keep on hand. So the night that Lou disappeared, I actually had ran out and was going to have to go to the store to get more.
How did your trip to the store go?
Went fine until I was headed back towards the Cubs, and that's when my car broke down. But I didn't have my phone, so I was going to have to flag somebody down in the middle of the street, and that's what I had to do.
Were you able to call for help?
Yeah, I was able to get someone's phone, and I called my brother, who was a deputy sheriff that was actually patrolling the area that night, and so I knew he could probably come to me pretty quickly.
About what time did you call your brother?
About 3 o'clock in the morning on August 18th, 2012.
Was your brother able to get you home?
Yes, he came and picked me up a little while after I called him, and then we headed straight back to the Cubs. So, shortly after he picked me up, we were home.
When did you realize that your husband was missing?
Later that day.
What did you do when you realized he was missing?
I reported him missing to the police, of course.
What happened after you reported your husband missing?
So I waited. I was waiting to see if I would hear from Lou. I was waiting to see if I would hear from the police. I didn't hear from anybody. And after so much time had passed, I started to realize that I wasn't going to hear from anybody. And so I was going to have to make the decision to move on with my life.
How much time passed?
It was 5 years. 5 years is a very long time to sit and wait for answers. So like I said, I had to move on with my life.
How did you move on?
I made the decision to have, petition the court to have Lou legally declared dead.
Why did you do that?
It was the only way that I could, make sure that I would have enough to provide for the cats at Wild Wildlife, because once I had him legally declared dead and the court granted my request, I was able to then probate his will and then make a claim with Summit Life Insurance Company.
Directing the court and opposing counsel to what has been marked with Bates number 0014 for identification purposes. Your Honor, may we have this exhibit marked as Defense Exhibit C for identification?
Certainly. Exhibit C, it'll be marked as.
Ms. Beja, have you located the exhibit?
Yes, I have.
Do you recognize? Oh, I'm so sorry. Your Honor, my apologies. This exhibit is actually already in evidence. At this time, we would like to recall Plaintiff's Exhibit 6. I apologize.
All right. Exhibit 6, you may publish.
Thank you, Your Honor. What are we looking at here, Ms. Beja?
This is my husband's will.
And whose signature do we see? The first signature, whose signature is that?
That's Lou's signature.
How do you know that that is Lou's signature?
I know that it's his because I watched him sign it.
What, if anything, did you inherit under this will, Ms. Beja?
After I probated this will, I became the sole owner of Wild Wildlife.
And was Cam Donaldson mentioned in this will?
No, she was not.
Whose decision was it to leave Cam Donaldson out of this will?
Lou wrote the will. So Lou got to decide, what he wrote in the will, and he didn't add Cam to the will.
Ms. Beja, were you aware of Lou having any other will?
No, this is the only will Lou had.
Mr. Villarreal, if you would stop sharing the screen, please. Ms. Beja, you mentioned before that you filed a claim for Lou Donaldson's life insurance policy. Did you receive anything as a result of that?
Yes, so Lou had taken out a life insurance policy back in 2005, and he named me the beneficiary. And so once I made the claim, they paid out $5 million for that life insurance policy.
What do you plan to do with that money?
So I'm going to be able to use it to keep Wild Wildlife going. Lou loved those cats, and that's what he would have wanted. So I'm finally going to be able to do that.
Now, I'd like to talk about what brings you into court here today. How did you become involved in this case?
I'm here because Cam Donaldson, the plaintiff, has sued me after her father disappeared. She is making some ridiculous accusation that I was responsible for Lou's death.
How would you describe your relationship with Cam Donaldson?
You know, Cam is my stepdaughter, but she's never liked me. And I know that she's never liked me, but she's never gone as far as doing something like this and accusing me of something this ridiculous.
You mentioned that you think it's ridiculous. What makes you say that?
Why would I be involved? I loved my husband. We were soulmates. We shared the same passion, the same dreams and hopes. We loved working at Wild Wild Life together. You know, Cam says that I was involved in her dad's death, something about, you know, a meat grinder.
Narrative calls for ultimate issue as well.
Sustained as to narrative. I'd like to break down or ask another question you may.
Yes, Your Honor. You mentioned that you weren't involved in your husband's disappearance. Miss Beja actually scratched that, I'm sorry. Were there any investigations done into your husband's disappearance?
Yes, so two specifically. The first one was done by Summit Life Insurance Company once I made that claim through the life insurance policy. They did a thorough investigation and they found that I did nothing wrong.
What about the sheriff's office?
So the sheriff's office has never named me a suspect. They never approached me about this. And they even came to the Wild Wild Life property and they looked around and they found no evidence there either.
Miss Beja, did you have anything to do with your husband's disappearance?
No, absolutely not. Lou and I were soulmates. It is devastating to lose a soulmate. If he could still be here today, that's all I'd want.
No further questions at this time, Your Honor.
Examination.
Miss Beja, when you met Lou Donaldson, he was already married.
Yes.
And he was 20 years older than you?
Yes, that was the age difference.
You started a romantic affair with him?
We had a relationship.
And at that point, he left his first wife?
Yes.
And married you?
Yes.
Objection, Your Honor. Relevance to this line of questioning?
Counsel, what's the relevance?
Your Honor, it's our theory of the case that Miss Beja killed her husband because she wanted to collect the money for Lou Donaldson's life insurance policy and his estate, and this goes to show her credibility with regards to her husband's relationship.
I'll allow it. I'll give you a little leeway. Overruled.
Miss Beja, after nearly 12 years of marriage, you said he started seeing somebody new.
He had a mistress in Costa Rica.
Right, and he also told you he wanted a divorce.
He said it once.
And so you were about to become the second ex-Mrs. Donaldson.
No, we were working on our marriage.
Okay. So you say you love working with these big cats, as you call them?
Yes, they're like my babies.
And in your words, I believe you call them your furry family.
That's correct.
You started working at the Wild Wild Life when you married Lou.
Yes.
And you two worked together for 12 years?
Up until he disappeared, yes.
Lou was the owner?
Yes.
And if Lou went through with the divorce, you would have lost your job there.
I don't know that.
If Lou went through the divorce, you would have lost access to his wealth.
He wasn't going to go through with the divorce, so I don't know that.
Okay. So speaking of this furry family, you say that on the last night that Lou Donaldson was seen, you were tending to these newborn cubs?
That's correct.
And but besides them, the only person that saw you that night was your brother?
Yeah.
You called him, you said around 3 a.m.-ish,
Yes.
and he got you home around 4-ish.
I'm not sure what time it was.
So besides your brother, he is the only person who saw you that day.
Besides my brother, who is the only person?
Your brother was the only person who saw you the night your husband disappeared.
That's correct.
You've been listening to this whole trial today?
Yes, I have.
So you heard Cam Donaldson testify about her father's will.
I heard her say that.
In that will, Lou split his assets 4 ways.
That's what Cam says.
Right, but the will you presented didn't split it 4 ways.
I mean, Lou's actual will didn't do that, no.
Didn't split it 2 ways?
Lou's real will gave everything to me.
Lou's real will cut out the wildlife animals he so loved, right?
Well, he knew I'd take care of them, so I don't agree with that.
Right. Ms. Baja, you claim that Mr. Donaldson was your soulmate.
Yeah, he was.
And that when he left, you were devastated.
I didn't know where he went, you know, it's hard, it's devastating.
You didn't know where he went, but on August 17th, you claim he went to Costa Rica with his mistress, right?
I assume that's where he went. That's where he was going all the time.
Because according to you, he would go off on his own, like on unannounced trips, right?
Sometimes, yes.
But he always came back in the past.
Yeah, he did.
But this time, you didn't go and try to look for him in Costa Rica.
No, I didn't do that.
You didn't even try to call him to see where he was.
I don't know whether I called him or not. I have no knowledge of that.
You didn't try to text him?
I have no knowledge of that.
Or email him?
I have no knowledge of that.
And you say that at some point you just needed closure, right?
After 5 years, yes, I wanted closure.
A divorce would have brought you closure, right?
My husband was missing, so you know, I wasn't thinking of getting a divorce. I was thinking of what I can do to move forward with my life.
Right, because if you file him dead, you collect on a $5 million life insurance policy.
Yes.
And then you can officially collect on his $5 million estate.
I became the sole owner of Wild Wildlife, yes.
No further questions, Your Honor.
Redirect.
Briefly, Your Honor. Ms. Beja, opposing counsel asked you about having your husband legally declared dead. Why did you wait 5 years?
5 years is actually a standard amount of time that you have to wait according, you know, to, I guess, the law. It's not a time period that I
have your opinion, Your Honor.
Overruled. You may proceed.
I'm sorry, could you repeat the question?
Oh, Your Honor. Yes. Why did you wait 5 years to have your husband legally declared dead?
So like I was saying, 5 years is just a standard amount of time that you have to wait when someone is reported missing and you hear nothing back. That's a time that I didn't create that. That's what I was told. So I waited. And once 5 years passed, I had to take care of Wild Wildlife. So I had to do what I had to do.
What were those 5 years like, Ms. Beja?
I mean, agonizing would be a really great word to describe it. It's just not knowing anything and hoping each day that you would hear something back, but that didn't happen for me.
No further questions, Your Honor. May this witness be excused?
Yes, this witness is excused. Next witness from the defense.
Your Honor, the defense has no further witnesses. We do have a motion, however, that my co-counsel will be arguing.
All right.
before the end of trial motion, may I have a quick time check, please?
Let's go ahead and do the motion. I'll let them calculate the time, and then we'll get it then. Okay.
Yes, Your Honor. Thank you. Your Honor, we would renew our Rule 50 motion under the Federal Rules of Civil Procedure and ask this court for a judgment as a matter of law, as no reasonable jury could find that the plaintiff did in fact prove their case in each element of that case.
All right. Any response?
Your Honor, as I said, as we rested our case, I think there's even more evidence that has come out during the defense's case regarding the credibility of the defendant's alibi, the credibility of their expert, the fact that the defendant herself declared Lou Donaldson dead. That combined with all the circumstantial evidence that came out on our case in chief, this evidence is more than sufficient for a reasonable jury to find that Ms. Beja was involved in her husband's death, and we ask the court to deny this motion.
All right, the motion is denied. Let's do a quick time check.
So for the plaintiff, they have used a total of 46 minutes.
All right. Plenty of time to still do a closing. I hope you don't necessarily use all of it. And for the defense?
The defense has used 55 minutes.
Okay, so approximately 15 minutes or so for a closing argument. We'll leave that as part of it. If I may, I just want to double check with the advocates and with, and I believe it's, if I'm pronouncing it correctly, Ms. Myers and Mr. Farchione, if I'm even close. How are we doing? Do we need a break, or are we okay to just power through?
I could power through.
Okay. Mr. Farchione?
Yeah, I could power through too, and that was very good pronunciation.
Okay, great. Thank you. Advocates, you're outvoted. It doesn't matter. We're going to go ahead and proceed.
Your Honor, at this time, plaintiffs would like to request 2.5 minutes for rebuttal.
Certainly. You have reserved time for rebuttal.
And may I just have a moment to adjust my camera, and then plaintiff is ready to go.
Certainly, and we want to just turn off the cameras so that, as I said in my pretrial ruling, that the advocate will have the full screen.
Your Honor, can I inquire, can the
You just cut out there for just a second. You were fine, and then you just cut out.
Can you hear me?
Yes.
May I proceed?
You may.
Members of the jury, the facts you've heard and the evidence you've seen today may feel like a TV show, but Cam Donaldson's loss is very real. She lost her father, she lost her job, and she lost her inheritance. And the defendant still reaps the very real benefits from her actions. She made up a mistress to cover a murder. She forged a will to secure a fortune, and she faked the scene to become Tiger Queen. Today, the issue for you to decide is whether the defendant will be held responsible for her actions. As the judge instructed you, the plaintiff has the burden of proof in this case and must prove their claim by what the law calls a preponderance of the evidence. To be clear, this is not beyond a reasonable doubt, which is a standard you would normally see in a murder trial or on a TV show like Law and Order. That standard is significantly higher than what we have to prove in this case. In order to meet preponderance of the evidence, we only need to show that it's more true than not that the defendant intentionally or recklessly caused Lou Donaldson's death. What that means is if you were given a scale and on one side you weigh all the evidence we've brought you today, And on the other side, you weigh the defense's evidence. If that scale tilts in our favor, even by the slightest amount, then you must, not may, but must return a verdict in our favor. Today, that scale has tilted in our favor because the evidence has shown two things. One, that Lou Donaldson gave the defendant a better life. And second, that she killed him to keep it. So let's take a look at that first point, that Lou Donaldson gave the defendant a better life. You heard today that the defendant was hitchhiking when she met Lou Donaldson and realized she struck gold. Not only was he a successful self-made businessman, but he was the owner of the Wild Wildlife Emporium. He was her ticket out of poverty. And even though when they met, he was married and he did have a child, he was willing to give all of that up in order to pursue a relationship with her. Being with the defendant gave her not only purpose, but the opportunity to live her dream life, taking care of the animals. She said it herself, he was her knight in shining armor. But after some years, the defendant's spell over Lou Donaldson started to wear off, and he was threatening to leave her. Now, earlier today, the defendant talked about no marriage is perfect and theirs had problems like other people. But members of the jury, their relationship didn't just have problems. Their relationship was deteriorating. You heard from Cam Donaldson today that she frequently overheard the defendant and her father arguing. In fact, in their last argument, just weeks before Mr. Donaldson disappeared, he was so visibly shaken by their argument that he walked out and he told his daughter, if anything happens to me, make sure the police look into Karen because she'll be the one responsible for my death. Now, the defense has tried to confuse you and tell you that Mr. Donaldson just upped and left to be with his mistress in Costa Rica. But there's nothing to prove that. There's no letters, there's no photos, just a convenient truth. However, even if it was true, do you really believe that the defendant found out her husband was having an affair and she wasn't upset? No. Remember, members of the jury, just a few years ago, she was the other woman. This was deja vu, and she knew better than anyone else exactly how this story was going to end. Lou Donaldson was done with the defendant and done with their marriage. She even had to admit that to you today on the stand. But his escape plan was to divorce her. It wasn't to disappear. The defendant realized she might leave this marriage exactly how she entered it, empty-handed. She was going to lose her husband, her cool cats and kittens, and the lavish lifestyle that she had grown accustomed to. Members of the jury, she wasn't going to let that happen. Which brings me to my second point, which is that the defendant killed Lou Donaldson in order to keep the life he gave her. Now, in a moment, we're going to unpack everything we know about Mr. Donaldson's death. But before we unpack those things, I want to discuss what the law calls circumstantial evidence. As the judge previously instructed you, you can and should equally consider the direct and circumstantial evidence in this case. Circumstantial evidence means that facts may be reasonably inferred based on the existence or non-existence of other facts. An example of circumstantial evidence would be if you walked outside and the ground was wet, cars are wet and the skies are gray, you wouldn't have needed to see the rain in order to reach the conclusion that it was raining. So let's take a look at both the direct and circumstantial evidence in this case, starting with the timing of events and Mr. Donaldson's own behavior. Mr. Mays, can you please share the timeline? First, you learned that a court document was filed on June of 2012. And then just 2 days later, Lou Donaldson allegedly signed this will that left everything to the defendant. Members of the jury, this story doesn't just stop there, because 2 months later, Lou Donaldson disappeared. And from the day after, he disappeared on August 17th, 2012. Then by August 19th, that Sunday, the defendant broke into the Wild Wildlife Emporium. And that following Monday, August 20th, she took over the company and shortly after fired Cam Donaldson. Then 5 years later, she decided to declare him missing. And why is the timing of these events so significant, members of the jury? Because you heard today, Lou Donaldson took spontaneous trips all the time. The defendant even told you her husband would frequently leave the country and not tell her. And then she told you on August 17, 2012, Lou Donaldson, once again, got on his plane and went to Costa Rica. But she didn't tell you why this time was any different. Yet this time she declared him missing. This time she took his will, and this time she took over his company. Yet there was no single explanation as to why. Members of the jury, she knew this time was different, and she knew Mr. Donaldson wasn't coming back because she killed him. Now, the defendant has an alibi for the night that Mr. Donaldson went missing, the cats and her brother. Yet no one saw her with the cats. And she couldn't tell you exactly what time her brother picked her up or returned her home. It was all unsure for her. But that same brother who picked her up in his police car, magically, right at the time he picked her up, the transponder in his vehicle stopped working. Which means that there is no one and nothing that can verify where the defendant was that night. And they further try to mislead you, talking about Lou Donaldson's glasses and vans that were found at an airstrip. But Cam Donaldson told you today, her father was blind as a bat without his glasses. So there's no way he could have flown a plane. And members of the jury, most of us don't even go to the grocery store down the street without our keys and our glasses. Yet the defense expects you to believe that Lou Donaldson left the country without both of those things. All this misdirection was to ensure she kept her cats and her cash. Now, the document that was presented, or you heard testimony today about Lou Donaldson's original will. That will split his assets 4 ways amongst everyone and everything that he loved. But that's not the document you saw today. Mr. Mays, can you please publish that document? Members of the jury, you know that this is not Lou Donaldson's original will. This is a forged copy of it. One of the main reasons you know that, just look at the signature. We brought you our expert, Taylor Pride, in handwriting analysis and investigations. And she told you that she looked at this signature as well as the signature on the court document just 2 days before. And that when she compared and analyzed, she reached the conclusion that this signature was fraudulent. There were quivering lines. You can see them yourself. A common indication of forgery. She also told you that the person who signed this document, they lifted the pen way more frequently than in any of Mr. Donaldson's other previous known and verified signatures. Yet another sign of forgery. But wait, members of the jury, you heard also from the insurance investigator who tried to insinuate that this signature was authentic. Yet his opinion is entirely unreliable. He wasn't even aware of a document that was filed just 2 days before. So he didn't even compare that, the most recent signature, in his analysis. He also received a letter from Samantha Lane, one of the witnesses to this document, and she said that she was coerced into signing as a witness and that she never saw Lou Donaldson sign this. And what did he do with that information? He chose to disregard it. But wait, members of the jury, there's more. And I know I'm starting to sound it like an infomercial, but the list of problems with this document truly go on and on. You heard that there were 2 witnesses to this will, Samantha Lane and the defendant herself. Our expert, Taylor Pride, testified today that when he spoke to Ms. Lane, she said that she didn't see Lou Donaldson sign this document and that she only signed as a witness because the defendant threatened to feed her to the cats if she didn't. Remember, this is the same threat that she made to Exotic Bob. And the red flags, they still don't even stop there. Because both the insurance investigator and our expert told you that the language contained in this document was suspicious. Specifically the phrase, "if I die or disappear." In the hundreds of wills that they've each independently reviewed throughout their careers, neither of them have ever seen that language contained in a will. Yet, in this case, Mr. Donaldson just so happened to disappear. So what are you left with? A will that contains never before seen language, a clearly forged signature, where one witness was threatened with death and the other witness is the sole beneficiary with 10 million reasons to kill. Members of the jury, your common sense tells you that this isn't Lou Donaldson's original will. The defendant realized that she was going to lose everything. So she took matters into her own hands, killed Lou Donaldson, and left Cam Donaldson with absolutely nothing but her own grief. Remember, at the beginning of this trial, my co-counsel, Mr. Mays, told you we would speak at the end, and we would talk about the value of Lou Donaldson's life and his relationship with his daughter. As the judge instructed you, your job today is not only just to consider what's happened in the past and the history of their relationship, but your job today is to also to look forward. Your job is to try and put a number and assign a value to Lou Donaldson's life. And members of the jury, we understand that that is an impossible task because no amount of money is ever going to give this child her father back. Now, most kids grow up and they see their parents once, maybe twice around the holidays, but not Cam Donaldson. She got to spend every single day with her father. They worked side by side and she got to help him build his life project and passion. She got to be there as he continued to live out his dreams. And even after he left her mother, day in and day out, she stood by his side. But the defendant has robbed Cam Donaldson of many precious moments with her father. When she gets married, there will be no father-daughter dance. When she has children, they're never going to get to meet their grandfather. There will be no more days at the Wild Wildlife Emporium, and Cam Donaldson will never get the chance to say goodbye. Your job today is to assign a number to the missed Sunday dinners, the lost conversations, and the dad jokes that she will never get to hear. What is that worth, members of the jury? $1 million? $2? $10 million? That's for you to decide. When these closings are over, you're going to be presented with 2 verdict forms, but you only need to fill out one. Mr. Mays, can you please share the verdict form and show them where they should sign? Sign your name right here. Return a verdict that holds the defendant responsible for her actions. Return the only fair verdict that is consistent with the evidence and demanded by justice. A verdict in favor of Cam Donaldson.
Thank you, counsel. Closing from the defense. And for the plaintiff, there are 2.5 minutes reserved for your rebuttal.
May I proceed, Your Honor?
Whenever you're ready.
I hate her. I hope she is attacked and eaten by one of her tigers. That's what the plaintiff had to say about Karen Beja. And that's why we're here today, because the plaintiff hates Karen Beja. Granted, she has her reasons for hating Miss Beja. Her father left her mother and married Karen Beja. Her father left his life insurance policy to Karen Beja. And probably worst of all, her father left his business to his wife, Karen Beja. A business that the plaintiff spent 20 long years working at. A business that the plaintiff now claims should be hers. Blinded by her hatred, the plaintiff sued Miss Beja. The problem is, members of the jury, the legal system isn't in place to pacify children who hate their stepmothers. The legal system is in place to right legal wrongs. And before the plaintiff could be awarded any money in today's case, she had to prove that Karen Beja violated the law. In fact, she had to prove that Karen Beja violated this law. But while the plaintiff had to prove that Lou Donaldson is dead, she hasn't shown you a body. While the plaintiff had to prove that Karen Beja caused his death, she hasn't shown you a single piece of physical evidence that Karen Beja ever even harmed him. And while the plaintiff claims that she is entitled to Lou Donaldson's entire estate, she hasn't shown you any evidence that Lou Donaldson ever intended that result. Now, I'm sure you remember plaintiff's counsel saying that they had to prove that these elements were more likely true than not. And that sounds simple. Each element just has to be over 50% probable. The thing is, if one explanation is over 50% probable, no other explanation can be more likely. In fact, no other explanation can even be as likely, which means that that one offered explanation has to be the most likely one. In this case, that means that the plaintiff had to prove that the most likely explanation for Lou Donaldson's disappearance is that Karen Beja caused his death. What seems more likely? Karen Beja killing her husband, an explanation that no one has found any evidence for, or Lou Donaldson crashing his plane somewhere between Statesville and Costa Rica. You heard today that there are 2,200 miles between Statesville and Costa Rica. You heard today that that was a trip Lou Donaldson made often. You heard it was a trip Lou Donaldson made alone. You heard that was a trip Lou Donaldson made without filing any flight plans. Lou Donaldson could have crashed his plane anywhere on that 2,200 mile route, and no one would ever know when or where. What seems more likely? Karen Beja killing her husband, a man she loved, a man she was married to for over 10 years, or Lou Donaldson quietly disappearing to be with his mistress in Costa Rica. You heard today that Lou Donaldson was a loner. You heard that he would often go and do things And he wouldn't always tell people when or where he was going to go. And the only evidence that the plaintiff has to prove their theory that he didn't go to Costa Rica is that their experts sent one person to investigate the entire country of Costa Rica. What seems more likely? Karen Beja killing her husband or someone else killing him? Someone else with more anger, someone else with more greed, someone else with more hatred, someone who worked for Lou Donaldson, someone who knew all the ins and outs of the wild, wild life business and wanted it to be theirs. The reality is there are a million more likely explanations than the one that the plaintiff wants you to believe, which is why it's clear that the plaintiff hasn't even proven the first two elements that she had to prove to you. But not only did the plaintiff have to prove that Lou Donaldson is dead and that Karen Beja caused his death, she had to prove that she suffered damages as a result. But you saw Lou Donaldson's will. It leaves everything to Karen Beja, meaning that the plaintiff wasn't to inherit anything from her father anyway. Now, the plaintiff claims that the signature on this will is a forgery. But you heard from Chris Renard, an expert in signature identification, and he told you that because of the similarities between Lou Donaldson's known signatures and the signature on this will, it was impossible to conclude that the signature was a forgery. Taylor Pride, the person the plaintiff paid to investigate the validity of her father's will, claims that it's a forgery. Taylor Pride claims this despite the similarities between Lou Donaldson's known signatures and the signature on the will. Taylor Pride also claims that Karen Beja is responsible for that forgery. But despite having the expertise and a known sample of Miss Beja's handwriting right there on that same will, she chose not to confirm her suspicions. Taylor Pride also claims that Karen Beja is responsible for Lou Donaldson's disappearance. The reality is the only reason Taylor Pride was able to come to these definitive conclusions in today's case is because the plaintiff paid her to do so. Because Lou Donaldson's will left his estate to Karen Beja, the plaintiff wasn't meant to inherit anything and can't have suffered any damages as a result. Plaintiff also claims she's entitled to Lou Donaldson's life insurance policy, but she hasn't shown you any evidence that she was ever even a beneficiary under that policy. So she never would have gotten that money either. Lou Donaldson's disappearance was tragic, but the plaintiff didn't bear the burden of making you feel sympathy for her today. She bore the burden of proving that Karen Beja caused that suffering, and she has failed to do that. While the plaintiff had to prove that the most likely explanation for Lou Donaldson's disappearance was that Karen Beja caused his death, there are so many more likely explanations. It's more likely that Lou Donaldson went to Costa Rica to be with his mistress. It's more likely that Lou Donaldson crashed his plane trying to get there. It's more likely, based on the evidence the plaintiff has shown you today, it's even more likely that the plaintiff herself killed Lou Donaldson than that Karen Beja did. The plaintiff was with her father the night he disappeared. The plaintiff spent 20 years working in her father's company without ever rising above an assistant's position. The plaintiff, despite being so concerned about her father, didn't hire someone to investigate his disappearance until it was almost time for Karen Beja to get the life insurance money and probate the will. plaintiff claims that all Miss Beja cares about is money, money, money. Well, even if that were true, Karen Beja wouldn't be the only one. See, the plaintiff claims that there was an alternative will that left a quarter of her father's estate to her. But that's not what she wants today, ladies and gentlemen. She wants everything that Lou Donaldson left to his wife. You've seen all of the evidence, and it is clear that this story the plaintiff has concocted about Karen Beja killing her husband is just that, a story that was created from the plaintiff's perspective, a perspective that we've seen is clouded by her hatred for Karen Beja. But while the plaintiff can't see clearly, you, the members of the jury, you provide a fresh perspective. You have the ability to look at all of this evidence clearly and objectively and come to an unbiased decision in today's case. We all have the right to leave what is ours to whoever we want. Lou Donaldson exercised that right. He exercised that right when he left his estate to his wife, Karen Beja. Lou Donaldson intended for his wife to take care of the cats that they both loved. And he intended the life insurance money to help her do that. Just because this isn't the result that Cam Donaldson wanted, doesn't mean it isn't the result that Lou Donaldson intended. When you go back to deliberate, you'll have two verdict forms to choose from. Based on the evidence you've seen today, the only logical choice is verdict form B. Verdict form B is the only logical choice because verdict form A required the plaintiff to prove every element of her case to you today, and she has failed to do that. Just because Cam Donaldson is blinded by her hatred for Karen Beja does not mean that she gets to take what Lou Donaldson left his wife. Find Karen Beja not liable by signing verdict form B. Thank you.
All right, and now the rebuttal. And I believe it's, you requested 2.5 minutes. Timekeeper, if it becomes time, just go ahead and call time.
Okay, no problem.
Whenever you're ready.
The defense just stood here and asked you to point the finger at Cam Donaldson and believe in a bunch of more likely. But what they're really asking you to believe is in a bunch of coincidences. They want you to believe that coincidentally, the defendant had telepathic powers and was able to guess that her husband was never coming back. You didn't hear any testimony today that on the news, she saw evidence of a crash and just knew that was her husband. You didn't hear evidence today about she called and he wasn't answering and she knew he wasn't in Costa Rica. In fact, you didn't hear anything that she even tried to find out where her husband was. She just somehow knew in less time than it probably would have taken him to get to Costa Rica that he didn't make it. And her plan of action wasn't to send out a search party, wasn't to go get help. Her plan of action was to take over his business and take over his company. And speaking of this business, she emphasized to you today on the stand that Lou Donaldson wanted her to have the company and wanted her to protect the animals. But members of the jury, in the 12 years that they were together, she didn't even have a key to the front door. When she wanted to get to the Emporium after hours, she had to break in. You saw the photo. She didn't have a key. She couldn't dismantle the alarm, which is why Cam Donaldson was called. And coincidentally, again, after she broke in and was seen carrying a lockbox, Lou Donaldson's original will was never seen again. There was no trace, but yet again, another coincidence, this document appeared, which left everything to her. This document, which you've seen all the questions and we really don't have to spend much more time on because you can see the signature for yourself. This isn't a case of coincidences. It's a case of calculations done by the defendant. Return a verdict in favor of Cam Donaldson.
All right, that concludes our trial. Very nice job by the advocates. Congratulations, you got it done. That's great. It's late. We're gonna just go and submit scores and then feedback as well. And so, congratulations. You competed in a Zoom tournament. Like, who would have thought that was even a possibility as attorneys just even a year ago? So excellent job by all of you. I know you're all going to do well. So just keep plugging away. You're doing great. And as far as Ms. Myers and Mr. Farchione, I believe that we'll just give feedback that you're going to give written feedback on the score sheet. So we just go to Basecamp, we submit the scores there, and we should be good to go. I wish you all the very best.
Thank you so
everyone.
much.
Good night.
Everyone for their time. Thank you, Judge.